Good evening. I'll open the record for the planning board meeting on Thursday, June 29th, 2023 at 7:19 p.m. here in Ashland Town Hall. And we're going to begin our meeting with the clerk's reports.
Since the last official clerk report, 5/11/2023, the board has received 9 correspondence. 7 of those correspondence have been responded to by the clerk, town planner, or chair. 2 of those were received today and have not been responded to. In fact, one of those, Peter, I think was a resident asked for the link. I don't know if it's appropriate to try to email it now or if it's
Already taken care of.
Okay.
I'm sorry, I did not reply all.
Yep.
Just so I wasn't filling up everyone's email box.
Okay, so 8 of the 9 have been responded to. I also would like to specifically make a correction. We received an email from a resident stating that Michael Herbert and Catherine Jerzyk had met with a neighborhood, and I guess there's an imposter out there. I did not meet with the neighborhood. So I would make sure that's in the minutes for this meeting, and I also want to just report that I will reply all, because that went including to state government. I just like the record corrected on that.
Thank you. We now have our public comment. This is our general public comment. This is a new feature that the planning board is trying, where we welcome general public comment about planning board jurisdiction issues. The concept here is that we prefer project-specific comments to be made later on in the hearing relative to a specific project, so that we have full context for whatever project we're hearing and we can hear the public comment at that time. But if someone is here from the public to speak about general town things relating to planning, we would welcome that now. If there's any raised hands, Peter will call the public comment.
Thank you. So I see 2 public hands. One is Mr. Joel Beitman. Joel, can you please unmute yourself and introduce yourself to the planning board with your name and address?
Joel, you appear muted. Give us a moment here. We can now hear you.
First, I just want to really take a moment to thank the planning board for this. Are you able to hear me okay?
Yes.
Okay, great. I really want to thank you for doing this. You know, especially in that it's an elected board, I think it's really very important to hear from the public, whether it's at every meeting or how long, how much time is given or anything else. I think this is just great, and I really encourage you to try to find a way to make this work as well as possible, to give the residents a chance to be heard. So I appreciate this. Having said that, I want to address myself to the last meeting or 2 that I attended, where I was not overly thrilled, I don't know how to put this nicely, with some of the feedback that I received with regard to issues and concerns I raised about the Upper Charles Trail. And I'm raising this not to complain, not to criticize. It's not at all my intent. I'm trying to find the best way to work with the board. A couple of the comments that were made, to me, were fairly dismissive of the trail that our committee, a select board appointed committee, has been planning for the last 8 years. This is not like a Johnny-come-lately local project for a group of bicycling enthusiasts. This is a town project. Some of the comments that were made was that the trail is dreamlike, and another term that was used was aspirational. Well, both of those adjectives are true. For me, the planning board, and one other key statement was made that I really take objection to. The statement was made that that there's really not very much the board can do with this trail at this time, because there are no specific plans or documents before the board. Planning, for me, sometimes involves projects that are very far down the pipeline. There's detailed architectural drawings, there's engineering plans, there's traffic studies, and sometimes planning is at the very aspirational early stages of a project. This trail can produce detailed subdivision plans, and that gets fleshed out, and you work back and forth with the applicants, and that's all you do. And there's not actual planning involved, even at the earliest stages where there are no detailed architectural drawings, no engineering drawings, and so on. I think this needs to be revisited. I was very concerned that two of the former hearings that you held, which would have possibly, what's the word? It would literally wipe out the possibility of a trail in town. Those discussions were, and it's not that anybody on the board seemed opposed to the trail. Everybody was very supportive. There was an
appreciation for the value it could bring. One of the comments that was made, and this is my last comment on this, somebody suggested that perhaps a meeting between the planning board and the select board to try to ascertain exactly where the town is at with this and how formal a project it is and so on might be a good idea. Well, I want to second that. I think that would be very valuable, but I think we have to get, I think that it's important for the planning board to take into account when the project or the hearing that you're having is germane to the trail, which I hopefully will be alert enough to raise the issue, that a more detailed discussion can happen. Nobody's saying that the trail needs to be 100% accommodated, but it's deeply concerning when there's a level of dismissiveness and the issues that are being raised as concerns can't at least be evaluated and assessed and perhaps taken into consideration in your planning process. I have one other comment that relates to the specific hearing, and I certainly will save that until later. And I thank you for that.
Thank you. And it looks like we have another public comment.
Yes, the next public comment will be Mark DeSoni. Mark, please introduce yourself.
Thank you. Good evening, and appreciate the time in the front, so I won't have to be half asleep later on. And that's only kidding. I'm just joking on that part. And I'm just doing this for the a couple of agenda items that are on the agenda tonight. The first one is the Whittemore Estate. I would like to see the board get a little more strong-handed about what's not going on down there.
And Mark, why don't we take the comments on the specific projects a little bit later when we're hearing the projects? Do you have something general for us?
Okay. Yes, I would. My usual pet peeve, and I know that I've been involved in for a long time, updating zoning codes for this town to go forward, to be growing with, because the zoning codes here, yes, are out of date, and have the understanding that the town needs to be more worked on, and the office inside town hall needs to get the zoning codes up to date with development and offers more for the town residents and citizens who don't follow, something to see different than just the same old thing. Zoning codes, I believe in, is good now, but not great. And I also believe that if you're always looking for affordable housing issues, then the zoning code is going to go with that. But I'm looking at the future of the town, and I've been following the comprehensive plan, the standing committee and the group. I've been going to these meetings and all that, and I'm understanding that I may not be coming across too clearly, but I would like to be email form by the town planner of more zoning codes up to date, and the comprehensive plan steering committee. I've been channeling through the town manager, and I've been sending things out to him. He knows I've been doing that, and I know the comprehensive plan is going to be talked about by the town planners issued later on tonight. But zoning and citizen most improved understanding is needed for the town to go forth. I'll be quick at the end here. Yes, I've been doing this for years, and I know Peter's looking at the face of me and looking at me saying, when's he going to stop? It's more paperwork, but it's more forward paperwork. And to the town, to the planning board itself, is to town work for the town people, because you're voted into the chairs, and the select board, you two are the main boards for this town, other than subcommittees that we have. But it's also worth to know that within the planning board itself and the comprehensive plan and select board, the steering committee, the comprehensive with the zoning, needs to go forth and get heavier and more good at it. Thank you.
Thank you, Mark. Are there any other public comments? And it looks like there's no other public comment?
There's no other public comment.
Okay. And now we're moving to item 4, the planning board review and discussion of the Whittemore Estates definitive subdivision. And the next step in this is that we're going to have a presentation from our planner and town council. And then we will have the board ask some questions, and then we will open it up to public comment and discussion.
Thank you, Anna. So I just want to read this into the public record. It says, pursuant to General Law, Chapter 40A, Section 81U, and Section 344-8 of the Ashland Planning Board Rules and Regulations regarding the subdivision of land, construction, and installation of a subdivision has not been completed. The Whittemore Estates definitive subdivision was approved by the Ashland Planning Board on March 24th, 2016, with a decision for the vote filed with the town clerk on April 19th, 2016. The plan was endorsed by the Planning Board on July 11th, 2019, and recorded plan number 649 of 2019. More than 2 years have passed since the plan was approved. At this point, I would like to take the opportunity to introduce Town Council Brian Winters. Brian Winters works for Mead, Talaman, Mead, Talaman, and Costa, our town council. Lisa Mead, our town general counsel, was not available tonight, so therefore Brian is filling in. And so at this point, I just want to introduce Brian and let Brian talk and review the situation of where the town finds itself today and the action presented tonight to the planning board. Brian, I'm just going to hold on a second because I just want to see if we can get the audio working in the room. So I'm just going to put you on hold for a second. I'm sorry.
No problem at all. And I hope you can hear us on our end. I can hear you very clearly from my end.
Yeah, it's kind of scuffed over here. I'm sorry. I'm not sure if we can.
Vivian, I'm sorry. Would you mind moving
Yeah,
up
keep
just
my
one more row?
That's fine.
Okay.
They didn't let me in yours.
No. I think it's just,
Yeah, it's difficult to hear.
it is different at the work right there, so,
You can raise the volume a little bit.
yeah. All right, so thank you, Brian. We just moved some audience folks closer to the table so they can hear. So I'm just gonna turn the speaker up on my mic, my computer as loud as it goes, so. Brian, once I kind of give you a cue, the microphone's yours.
Thank you. That's the cue. So if anyone can't hear me or if I drop or break up, just please give me a signal and I'll try to repeat whatever it is that you missed. So thank you for the introduction, Peter. As you stated, my name is Brian Winter. I'm a partner at Mead, Tallerman and Costa. My office serves as town council. This matter was brought to my attention, a few weeks ago. In a slightly different context. It came to me through the Conservation Commission, but it appeared very readily to me that there were obviously grander issues that warranted review and possible redress. So I'd like to make 3 sort of introductory comments, and then I'll turn it back over to the chair. And the 3 comments are essentially just to identify what we're doing here tonight, how we got here, and then sort of conversely what we're not doing here tonight. And the last one's just as important as all the other ones, although it sounds a little bit awkward. I'll explain when I get to that point. So we, in particular me, interviewed a number of town officials and asked for documentation about the history, not only of the initial, permitting phases, but also the build-out phases of this particular portion of the larger subdivision, and investigating that, and in interviewing people and receiving, quite a lot of documentation, photographs, inspection reports, videos. There have been a lot of boots on the ground. There's been a lot of communication with the public and the residents, and so there was plenty for me to review. It became apparent that there are deficiencies in the construction of this subdivision. And that's not just based on my own personal review, but that's been confirmed by peer review consultants that have been involved in this process. And so I have, over the past few weeks, met with the Selectmen and the Conservation Commission, and I'm meeting with you here tonight as well. And I've consulted with your department heads and staff along the way. And what we have done is prepared what we sometimes refer to as a town council demand letter, which is a notice that my office provides, in this case to a developer, to put them on notice that we have certain claims and that we intend to pursue those claims if satisfactory remedial action does not occur. So you should all have a copy of that. That's a public record, and it's been circulated previously. So that is just a legal step that my office takes. Now, under wetlands jurisdiction, the Concom has certain requirements that it needs to undergo in order to enforce the rules that it acts under. The same is true for the planning board. So one of the steps necessary under the subdivision control law when a planning board becomes aware of deficiencies in the construction and build out of a subdivision is the step we're here to do tonight, which is, and this is noted in my demand letter that we anticipated this step, and that's to make a notice of claim of the deficiencies, provide that to the developer and the town clerk, and they have 45 days from receipt and filing of that notice to take action or not. After that time period, we get to pursue the bond that we're holding as security for performance of the completion of the subdivision, infrastructure, etc. Now that's a statutory step. It's a prerequisite to us making a claim on the bond. And as Peter will tell you, we're holding, the board recently revised and upped that bond amount. It's now just slightly upwards of $350,000. And we can't touch that until we go through this process. And so this is a preliminary step necessary for us for whatever comes next. And so we've done and sent a demand letter to put the developer on notice and the bond company on notice that we intend to seek compliance. And when we get to the next phase of this, if and when that comes, we're probably going to want to approach the bond company if necessary and seek that they turn over those funds so that we can pursue compliance. And we can't do that without this step. So that's how we got here and what we're doing, the first two things I mentioned. And so this is not a public hearing. It's just a step that the board needs to take. And Peter has a draft of the notice of deficiency that we prepared together, and you should have a copy of that. What I'm going to ask you to do after we get to the end of this agenda item is to review that and vote on that. So that needs to be a vote of the board to accept and adopt that notice. And you'll see there's two parts. One is, an identification of what the communication is. And the second part is obviously the notice of deficiency. And so all those are statutory requirements. They all have to be in there. And so that needs to come from the board. And then we'll file that with the town clerk and serve it upon the developer. So that's what we're doing here and what I'm going to ask you to do. I know that the applicants or developers council. I see him on the list of attendees this evening. I imagine he's going to want to address the board. I would venture a guess that there are residents of this neighborhood that are going to want to address the board. So although it's not a public hearing, I would certainly encourage you to take some public participation and comment, as that's the context that we're operating in here. And then the last thing I wanted to touch upon is what we're not doing here. This is just the statutory preliminary step. There's a much bigger picture going on here with respect to enforcement and compliance matters. I have been in communication with 2 attorneys representing the developer as recently as today, and we are communicating. There is a possibility that this may involve a litigation by and between a number of parties, some of whom are on this call tonight. And so some of the things that I would respectfully suggest we not talk about are things that concern a potential litigation position of the town or potential strategy with respect to future enforcement and other related matters. This before you tonight is a very simple, narrow bandwidth matter, just issuing the notice of deficiency. And I can't predict the future, so I don't know what's going to come next. And litigation enforcement may never come, or it may come. But my job is to look out for the best interests of the town. And so I'm making a recommendation that we, as far as is practicable, stick to the agenda item, which is just to consider the conditions of this subdivision and the notice of deficiency. I know that you'll very likely have some questions for me as the process and some other aspects of it. I'm happy to answer those, but just please keep in mind that I'm going to try to stick to my own rules and not discuss things in public that are probably more appropriate for an executive session. I have notified the Select Board, the Conservation Commission, and I'm telling you right now that if you'd like to hold an executive session, when it becomes appropriate to do so, I will make myself available at your convenience. And that would be the time to ask other kinds of questions when we can have that private attorney-client discussion. So with that caution in mind, I'll turn it back to the chair, and I'm happy to answer any questions.
Okay. Before we open it up for questions from the board, I want to make sure our town planner, if there's anything in addition that we need to hear from Peter as far as any other detail before we ask questions.
I just want to let everyone to know that within the packet after your agenda, you did receive the letter, which Attorney Winters has proofed and put together. The planning board does have to sign this if it's voted. I just want to make a note that I put Kate Jerzyk as the one to sign it because she is the clerk of the planning board. If the planning board decides to have anybody else sign it, I can make those edits and then we can just stay a little bit later. We can all sign it or have Anna, who's acting as vice chair, who's acting as chair tonight due to Trish's travel plans. That I just want to make note of that. Number 2, everyone did receive the demand letter. And I just want to make sure that everyone knows, and the colored pictures, and I'm sorry about the bad pictures that were sent out, but I just want to make sure everyone has that information before, obviously, we open up for questions to Brian and or myself.
So with that in mind, I can say I had like 4 procedural questions and a few substantive questions, but I know Tricia, our chair, is her hand is on. So I'm going to allow our chair to be the first to ask questions. Tricia?
Thanks, Anna, and thanks for taking on chairing this for me tonight. Obviously, I'm not present. I'm out of state at the time. I just actually I was going to let you open it up to the board, but I just wanted to clarify the statement made at the beginning of the meeting where Kate was correcting the fact that she wasn't at a meeting that had gone on with Whittemore Estates. So just for the rest of the board, and I'm sure some of the the residents who were here at this were the same ones that that I met with on site. Town manager Michael Herbert had planned a meeting for late Friday afternoon, this past Friday, with the residents of Whittemore Estates. And because Peter was not able to join, he asked if I would be interested in joining that meeting with the residents. So I did do that in order to listen and try to understand things from their point of view, and to bring that back to the board. Obviously, I think they're here probably then better able to speak for themselves. But I did want to clarify that point. They just got the names confused. That it was me that was there and not Kate. So with that, I'll just let you see if there's any other questions from the board. Thank you.
Okay. I had some procedural questions. I can start with those if that's okay. And rather than going one by one, I thought for town council's benefit, I could just give you my procedural questions as a grouping, and maybe your answer will answer most of them at once, if that works for you. Is that okay?
I'll do my best.
Can you hear us okay?
I can hear you. Can you hear me?
Yes. Excellent.
Okay. I'll try to get my
so
microphone as I can.
One very basic question I had, I would say I'm not super new to the board, to the planning board, but I am new to issues of pulling a bond. And so one of the things I wanted to ask about procedurally is what our options are. Is getting or enforcing a bond our only option? And is there, looking at some guides of planning, the guidebook to mass land use, there's this option to apply the deposit. And I wanted to understand what that was as an alternative to the bond. So that was question one, procedurally. And then a related question procedurally is the draft letter that we would send out, the 45-day notice letter. What would happen after the 45 days? Would we need to vote again for the bond to actually be pulled, if you will? Or would that letter at the 45-day mark automatically result in moving against the bond? Is it sort of automated? And then, so that's sort of question one procedurally. And then the other procedural question I had was deadlines. Do we have a deadline to vote today to issue the 45-day notice? Is there something statutorily that requires action today, some sort of deadline for us that we should be aware of? And then once the 45 days is up and we are acting against the bond, what are the requirements of the, I guess, the bond agency or company that we need to meet so that the bond is successfully pulled, if you will? How could that be challenged? Are there appeal rights by the applicant? What do we need to think about so that our pull of it is successful? Those were some of my procedural questions.
Okay, I'm just finishing my notes just to make sure I capture your questions
So
here.
kind of the options, the automation of the move against the bond. If the letter we're going to issue is going to sort of automatically at the 45-day mark, we are acting against the bond. Or whether there's a deadline for our actions, and then once we act against the bond, is it kind of an automated process, or does the developer get to challenge it again? And what are the reasons for the challenge that we should be aware of right now so that we can succeed?
Sure. So let me just take them in order, although they overlap. Your questions overlap a little bit. And so I'll kind of try to stay in sequence, but I'll touch upon a few. So you mentioned, is the bond the only option? What's this deposit? What other tools do we have, if any? And so I'm speaking in the abstract here. For the most part, we have a bond. And so that's our security for this subdivision. And as you are probably familiar, the subdivision control law requires the developer to provide a form of security, and there's 4 different forms of security that they can provide. We have a bond. And so by statute, as far as sort of an automated process of ensuring performance, we get to hold some kind of security. Sometimes that's cash, sometimes it's a tripartite agreement, a bond, and it can be a covenant. In this case, it's the bond. And
Got
so
it.
we have $350,000 that we can go after. That's not the only way to seek compliance for work that we feel hasn't been completed. And one of the alternative processes is what we're doing right now, which is to put the developer on notice that we're going to pursue this matter, and we have various tools at our disposal to seek compliance, and we intend to utilize them as appropriate. And so we always have the option of what we call equitable enforcement, which is another way of saying if all else fails, you can go to court. Now, that's obviously one of the more nuclear options, but it's always a possibility. The subdivision control law under 81Y allows the planning board to enforce its rules and regulations, and by extension, permits that it's issued. And so we can insist upon compliance. The problem with that, from an abstract perspective, is who's going to fund compliance? And so that's where the security comes in. And so those things kind of dovetail together a little bit. And mind you, these are all enforcement tools. There's nothing wrong with a developer, when they've been alerted to concerns we have, voluntarily cooperating. They can call me. They can call you. They can attend a board meeting and say, well, we don't think the problems are as bad, or we weren't aware of the problems, but we want to work with you. And so communication, I consider to be one of the tools in the toolbox as well, because it's always everyone's best interests in terms of resources and protracted litigation to try to do things cooperatively. And so the way to initiate that, obviously, is twofold. A letter from my office, typically, or from your professional staff, and then this notice that we're discussing here tonight. That's the statutory trigger. So those are some of the tools in the toolbox. Your second question, and I'm actually just going to combine two of them. Are we under any kind of deadline to take action? And no, there isn't a statutory deadline for us to do this or not do this in this particular situation. If the developer came in and sought a release of a covenant or a performance guarantee or anything like that, then we do have a clock for dealing with that. But in this case, we're the initiating party. We're the ones that have begun this process. And so we're not under any particular deadline to do it, other than a practical one, which is I'm informed that there are conditions out there which are non-compliant and causing problems for the residents, and this is our permit. And so there's a practical side to this, although there isn't a statutory deadline for us to necessarily take action. What happens after the 45 days? So the statute doesn't say anything other than if the developer has not certified to the town clerk that the work is compliant, then we get to go after the bond. So it doesn't explicitly state that there's an interim step that the planning board has to take. That being said, you're authorizing your staff and me to take certain actions. So for all intents and purposes, for subdivision control enforcement, you're the client, and I need that authority. And so if we issue this notice and 45 days has gone by and nothing has changed, then I'm going to be asking you to confirm that I'm authorized to take the next step. And not, obviously, this is a joint decision to a certain extent, because our appointing authority is, of course, the select board, and I'm also working with the Conservation Commission on other issues.
Hold on one second. We just can't hear you for a minute.
Okay.
Sorry. At least I only heard you through our appointing authority.
So I was just mentioning that we're working obviously in concert with other branches of the town and in coordination with them. So of course we'll be discussing this with the Select Board and the Conservation Commission. But what's going to happen at the end of 45 days is we're going to report the status. You're going to be aware of what's transpired in that 45 days, and then we'll make a decision. Do we give the bond company notice, which is what we're required to do? The town clerk certifies that nothing has happened. We provide that certification to the bond company, and then by operation of law, they're supposed to turn over the funds. So that's the kind of contemplated automatic side of things. Now, of course, doesn't have to happen that way because the bond company could just not do it. And so we would be compelled to pursue a claim or an action against the bond company or other parties. And so if everything happens the way it's supposed to, they get the notice, they determine that we in fact complied with the statute, and they release the bond funds to us. But everybody has an opportunity to dispute everything, and so they may not cooperate. And this is all just speculation. I'm not suggesting anyone is going to do something or not do something. This is all hypothetical. In which case, our remedy would be to pursue a claim against them for not doing what they're contracted to do. And then I think you had one last question, or maybe I addressed it already. But just to be more clear, I am going to come back to you or ask to be back on your agenda so that we can report the status, no matter what the status is, at 45 days, because I want the board, A, to be informed, and B, to make sure that I'm taking actions that are consistent with your guidance and your instructions. And so we're going to come back and tell you what's happened in that time period and what kind of response we've received. 45 days is a long time. We already know that attorneys for the developer have been alerted. They've contacted me. One of them is on this meeting tonight. And so a lot of things can happen in that 45 days. And so we'll update you on that. Did I miss any of your questions?
So I think the remaining one was just how would once we move against the bond, what challenges should we be aware of so that we can succeed in moving against the bond? Are there specific items that we should be thinking about now, whether it's certain type of documentation or anything in particular we should make sure we've done so that if we do move against the bond in 45 days, when you make the report and we decide to move against the bond, if that's what we decide, how would that be challenged either by the developer or the bond company so that we today, in issuing the 45-day notice, can be aware of what we need to do?
So we are taking those steps, and we're obviously mindful of all of those issues while we proceed. And the best way to, how should I say this, to have the highest likelihood of success is to A, have your evidence support the findings you make, and we've gathered quite a lot of that, and for your determination to be of a level of specificity that the developer and the bond company know what you're saying and what your cited deficiencies are, and that you have the evidence to support those. And so there's nothing in the statute that contemplates kind of an administrative appeal. It contemplates that the developer will comply or not comply. And so obviously the more persuasive, convincing, and evidence-based our notice of deficiency is, the more likely it is that we're going to be successful with the developer and the bond company. But there isn't an interim process for them to, for example, go to the zoning board or the select board directly and challenge any of those things. So really, what would happen as a practical matter is they just wouldn't comply. They wouldn't comply with our demands. They'd say, you're wrong, and we're not going to do the things you asked us to do. And so the burden would come back on us to then enforce. And that often means going to court.
So that answers my procedural questions. I have some substantive ones for later.
Yes, thank you for that explanation, and I think this is just almost an extension of some of the other subjects that Anna was touching on. And my concern is primarily on timing. I read all the documentation that was sent to us. I looked at the pictures. I went to the site, and well, I'm troubled by the possibilities and what I've read of some potential further deterioration of the site and what that can mean to the residents. So within these 45 days that we're talking about, and I agree with you that open the communication is the ideal way to go. Is there a chance that the communication maybe towards the end of those 45 days starts happening, but it's not, there's no full resolution? You said that we will wait, and at the 45th day, you will give us a report whether the problem has been solved. But this problem is not going to be solved in 45 days. So I want to understand what that would mean. And on the same note, if we get the bond and everything works well, my concern is what happens after that, knowing that the time that's going to take to make the repairs necessary to fix the situation, this cannot wait many more winters, I think. And I read of what has happened in the past winter and the danger that's attached to it. So I'm concerned that these will not, or some games could be played to delay and further delay the process, and then the resolution comes to a point where the problems are a lot bigger and not consistent with the estimate that we have. So if you could elaborate with that, I would appreciate it.
Certainly. And so just getting to your first point, all these situations and cases like this are very fluid, right? They're not ones and zeros. And so a lot of things can happen less than 100% compliance. And of course, that's, from our perspective, but more than, just complete neglect. And so I would fully expect that we'll land somewhere in the middle. I don't know if it's skewed to one side or the other yet. But let's say that hypothetically, the developer has mobilized contractors or people to come in and start to remedy some of these things. And you're right, it probably won't take 40, or it'll take more than 45 days. Well, we're going to be monitoring that, and we're going to be having a conversation around that. And so one thing that is certain is we can't go after the bond for 45 days. Our rights don't vest until that 45 days goes by. That doesn't mean we have to. And so if this board and the town, just sort of generally, town government that is, feels that sufficient progress is being made, and we've been online with the right people, and we've seen the right contracts and proof that they've been funded, and that the guardrails and benchmarks that we might look for are all satisfactory, well, we can continue to monitor that. And if compliance is progressing in a way that we're pleased with, maybe that's good enough. If it goes the other direction and we're not seeing the things that we would want to see, and we're not able to agree upon guardrails and benchmarks, and we don't see the kind of documentation to make us confident that these things are actually going to happen in a satisfactory time, well, after 45 days, we have the right to move forward. And so we can then say this isn't working, and make a claim on the bond or pursue other, equitable enforcement, as I mentioned earlier. But like I said at the beginning, it's not a 1 or a 0. And so that's why communication is important. And there's opportunity here in every one of these cases. And I've only spoken with the Developers Council once this afternoon for the first time. And so this is the very beginning of a conversation. Conversations are an ongoing process. And so let me just paint another hypothetical. And this is just based on a case that I have going on right now, another site that the town perceived as problematic. We met at Town Hall. We sat around for a few hours and went over all the issues and concerns. And then we sketched out a memo. And we put in dates and deadlines for certain high priority things to occur. We put in a process for inspecting and monitoring those. and we basically created a blueprint to get to success. And everyone signed off on that, and now we're monitoring everyone's compliance. So, there's lots of ways to climb the mountain here. And so I don't want you to think that we either get the bond or we don't, and that's the end of it, or we file a lawsuit or we don't, and that's the end of it. There are lots of variations on this theme, and that's why, another reason why I'm going to meet with you as is necessary to keep you informed and so that I can get proper guidance and instructions from you.
Any other questions from the board?
I have a question. So along the way, in your mythical case, someone starts doing some work, but and then we're not satisfied. And I guess I wanted to make sure, is it iterative? So the 45 days is up. We thought we were making progress. We're not. Do we go through this process again? Does it stop? I mean, it's not clear to me what happens. Presumably, there's already been some movement since we heard about this, right? So I don't have a clarity how that would work. That's one question. Another question is, I understand statutorily that the bond belongs, responsibility calling the bond, not with the planning board. I would like to know the background of how data collected by other town departments or agencies kind of affects something that we are calling or potentially calling the bond when that data was not specifically, to my knowledge, or at least since I'm one of the newest members, I am the newest member on the board, but I have not heard about this, so I would like to know how that affects the whole process.
Sure. So with respect to whether or not you'd have to reboot, it would really be, dependent on the circumstances. If the validity and merit of your notice of deficiency is intact, I would say no. If substantial progress has been made and the items we have delineated in the notice of deficiency are not particularly valid or relevant anymore, I would say it's worth rebooting. And so we won't know that until we get there. But the statute contemplates, unfortunately, it being sort of an all or nothing scenario where there's compliance or non-compliance. And in fact, what the developer needs to do in response is to comply and then certify their compliance. Now, we might not agree with that. And it might be partial compliance. It might not be compliance at all. But it doesn't contemplate a sort of incremental process, which is the reality of it. It's going to be an incremental process. You can't do it all in 45 days in one swoop. So we're going to monitor that. And if it needs to be refreshed, we may refresh it. If it doesn't, then we stand on our rights and we just proceed. Your second question had to do with, the sort of coordination with other, departments, boards, committees, and commissions, and each is in their own lane, if you will. So there's a little bit of overlap between, of course, subdivision control and the Wetlands Protection Act, but the Conservation Commission's jurisdiction is different. And, they're operating under a different regulatory scheme altogether. And so their process for enforcing is completely different than your process for enforcing. That being said, talking about the same site and the same information. And so I collect it all to the extent people want. We share it all so that everybody is working from the same, set of photographs and inspection reports. And we can all be informed by all that information. But certain things might be a violation of wetlands regulations, but not a violation of subdivision regulations, and vice versa. And some might be violations of both. And so as this progresses, if it takes on an enforcement posture, that falls on me to make sure that we proceed within the right lanes for each respective enforcement case. So some of the things that you haven't heard of, I'm guessing are things that occurred with the Conservation Commission. Enforcement orders, inspections, certain interactions about issues that are specific to conservation. And that wouldn't necessarily come in front of the planning board because they're not subdivision control issues. But part of my role here is to coordinate, and if you will, sort of be a point or a sort of field general to make sure that the town is advancing all the interests it's seeking to protect in parallel. And so I often will, we're not going to do these things piecemeal. It's not fair to the property owners, it's not fair to the developer, and it's not a very efficient way to go about doing this. So if we have wetlands issues, we have planning issues, maybe we have other issues, we're going to consolidate all those together. And so that's why, I'm referencing other information from other departments.
Do you have any other questions from the board before?
I mean, I sort of have a follow-up on that. I agree with the collection of one, all town, representing town boards and departments. Still, we have one specific issue that I'm wondering about the documentation for that. Like, so we are being asked to, sign a letter about something that there's a fair bit of documentation, but I don't know what hand the planning board had, and I'm not sure that makes a difference, but I don't think we've heard about that.
I can address that.
So
I think we both can. Go ahead.
Is that the bond, which the money kind of comes from, was submitted to the planning board. We were the granting authority. So GCG, working with the planning board, creates the bond. I mean, that's the list of work that hasn't been complete. The bond is obviously built off of that list of documentation, and that was given to us, the planning board, the planning office, to create that bond amount. So that was kind of done through our third-party review engineer.
And can I
That's
ask a question
specifically on
related?
behalf of the planning board. So the planning board, at some period, requested, or at least twice, because there was an updated estimate for a review of the site
So
by the planning board.
The first was done at the time of the last lot release. So as we granted the last lot release, we took a bond for surety. And then upon the last occupancy permit being granted, it was in the town staffs, we wanted to make sure that before we granted all occupancies, that the bond amount in January was up to date with the amount of work that was left out there, and or on Whittemore Estates, and that was done by GCG as an update to that bond amount.
Did we as the planning board review the rider? How did that come to be?
That was I don't know if the planning board reviewed it, but that was an
Okay.
administrative matter within town staff.
Okay.
I have a follow-up on the wetland question, I guess, and some of what I see in those pictures could be things that can result in fines. I don't know if that comes from Concom or from DEP and EPA, but if it does result in fines, is that a completely separate issue from the bond itself? Or would we be pulling from the same pot?
Would you like me to answer that?
Brian, I'm happy to answer it, but I don't know if I can try.
Well, you go first, I'll go second.
First and foremost, our conservation agent has been on this site every day, and the first violation that was issued dates back to, I believe, April of 2002. Every day, I have a list, and I did bring it, and I just didn't have time to put it in everyone's packet. So excuse me if I can find my hands on it. So I can pass this around the table to everybody. but our conservation agent has granted us a list of all fines and the dates. And so she has listed a extensive list of fines dating back to, like I said, 2022 April. And so on a daily basis, our conservation agent, Becca Solomon, who is the most thorough conservation agent I've ever worked with, is on that site every day, taking pictures, taking notifications, and she writes up fines daily and weekly, and the fines are sent via certified mail to the applicant. And so, Brian, you can jump in and add any light to that question.
Sure. So let me just add the legal perspective. The fines are a separate category. They are on a different track than any of the things we're talking about tonight. So fines are issued pursuant to a different statute, Chapter 40, Section 21D. We're actually in the Framingham District Court right now. There's a pending action to review those fines. And so that's happening sort of separate but parallel to our efforts here tonight. And it has nothing to do with the bond. Also, fines are fines, right? And so whether they're upheld by the court, whether they're paid, not paid, it's just a fine process. And so nothing changes on the ground. And so that's why we often pursue these efforts simultaneously, because while the fines can be incentivizing, certainly they accumulate very quickly, and they can be a very large fine if compliance isn't achieved relatively quickly. But it doesn't change anything on the ground. It doesn't reduce the bond, increase the bond. It doesn't do any work on the ground. And the fines ultimately just go into the general fund if we receive them. So completely separate from what we're doing here tonight.
Any other questions from the board? And so at this point, I would suggest we open up, if the board is in agreement, we can open things up for public comment, and then we can have a discussion as a board. So do you want to start with the folks online, Peter, or in person? What would be the...
I am happy to start with the folks online. And so with that said, there's actually two hands up. One is the attorney for the applicant, who I will start with in respect of his time.
Hey, good evening, board. My name is Arnold Cohen. I'm an attorney with an office in Hopkinton. I'm quite new to this case, just within the past week or two. But I want to say at the outset that my client, Chelsea Developers, wants to get this project done. We want to work with the town. I spoke to Attorney Winter earlier today. We're planning on meeting next week. There's another attorney who's going to be involved named Megan Delury from the law firm of Todd and Weld, which is a Boston law firm. And the idea here is to see if we can get agree on a punch list to try to get this done. Chelsea had a mortgage from the developer of this project, and the developer defaulted, and Chelsea became the owner of the property, and determined that it would be make more sense from their standpoint to rather than try to sell it to another developer, to hire their own developer to finish the project. And they did have a developer named Peter Venuto, who unfortunately 2 or 3 months ago had a very serious medical issue. My understanding, has been hospitalized, and my client was a lender, wasn't a developer, and while to figure out what's going on with Mr. Venuto, but we have entered into an agreement with a new construction company called Newport Paving to finish the road and everything else that's required. There's a gentleman named Barry Rutman, I think, from that firm, who's going to be involved. And we're also hiring someone named Scott Goddard, who's a wetlands scientist to help us on this. And what we want to do is we want to try to, at this point, to go ahead, get this thing done, work with the town, have a punch list that you know, is that's a reasonable punch list to get it done, and you know, meet with the town officials to work in that direction. So that's where we're coming from. I know partially what the break in communication in the past, I think, had to do with Mr. Venuto, who was, I think he was going to the meetings, and but now we've hired the company, and that's our position now. We want to try to make the town satisfy the town's reasonable requirements.
Thank you, Attorney Kevin.
Cohen,
I'm sorry.
Any other public comments, Peter?
Yeah, it's so hard. 1 minute. It's so hard dealing with the volume and then talking. I'm sorry. So the next person with their hand up was Mr. Mark Dissoni. Mr. Mark Dissoni, please unmute yourself and introduce yourself with your name and address, please.
Hey, Mark Sony, 49 Hawthorne Road, SNS. Yes. It sounds like a bump in the road has turned bumpier with change of personnel and personal things that happen. But still, the issues go on and on and on. To anybody that can answer this, chairman, attorney, whoever, what does, if they say they want to meet with the board, set a certain date with the issues, and yet comes up with a continuation, does that stop any clock of the 45 days to say why, or why can't you meet them? Or is it just an excuse that they're trying just to put it off? That's one question. You want to answer one at a time? I can keep on going.
Mark, why don't you go ahead and finish your questions, and then we can try to respond.
Okay, thank you. And it's because what the people there living there are going through for the years, they are still suffering with the results that hasn't been done. So evidence of responsibility is just not there with the developer, even though maybe Venuto has medical issues, and hiring a new attorney for about a week that's been there and just getting to the point now, getting to an idea. Issues still ongoing, and the citizens that are living down there are living through it day in, day out. That's another one I want to hear an answer on. And an issue is, in my mind, is how can the town not be embarrassed by this, and why did it take this long to have a meeting? And the attorney, Mr. Winter, Mr. Winter says it's about time. Well, two things that came up is communications. With no communication, there's no understanding. With no understanding, there's no road. And a two-way street, it has a detour with a giant pile up in the middle with no winners, or pardon the name there, but no winners and no people there understanding each other. This is they're arguing, pounding fists and saying what's going on, and the developers just laughing behind the board's back, saying we're going to do a continuance. Why did it take this long And how come we have to get another developer, which we have gone through, they've gone through 3 developers down there, I think. And the conservation meeting came up with the wetlands issues, yes, which is different from planning board. The planning board has this in front of them all the time, and yet there's no answer before them. Now it comes down to the way of saying things. Why would the citizens expect more to happen in the process to be positive when it's only been going backwards since now? Thank you.
Thank you, Mark. I will briefly say, only because I think the attorney earlier stated that what would happen is we would have 45 days and then we would be getting a status report. So I didn't hear that those 45 days could be extended, right, Peter?
No.
Yeah. So I don't think we have to worry about that, Mark. And I heard some of your frustrations about how the residents down there are suffering through multiple rounds of developers and continuations. And I can certainly speak for myself. I share your concerns, Mark, and I think that's why we're here, as trying to address them. I will say that it's been eye-opening for me to kind of see the extent of the failure to perform, obviously. And I can say that as a planning board member, I certainly want to explore through this particular case, and also just generally other cases that we handle, subdivision cases that we handle, so that when we release lots as a planning board, we're a lot more aware of, hey, how is it going over there with the residents? Hey, how is it going with Concom? Where are we with violations? Maybe we shouldn't release lots until we have some demands of performance. So I will certainly attempt to be a lot more thorough as a planning board member. And that's what I will say.
So the next person with their hand up is Mr. Joel Arbeitman. Joel, please unmute yourself and introduce yourself with your name and address.
Thank you very much, Peter. Joel Arbeitman, again, chair of the Ashland Upper Charles Trail Committee. One, I was not aware that some of these compliance issues were being raised. So what I want to address about this project is kind of a detail that is beyond the focus that I've heard tonight. It has nothing to do with the development of the site, non-compliance, or any of the legal matters before the board. What I do want to talk about, and I'd be happy to get some direction on what the best forum to raise this issue with the board would be. First, I want to make the board aware that as part of the original agreement, I guess with the original landowner or developer, the town of Ashland was granted an easement along part of the subdivision boundary around the parcel labeled as 6 Burnham Circle. That's the last parcel on the southeast corner of the subdivision. And there are some problems with that easement as to how it was granted. After the easement was obtained by the town, we were contacted by an abutter who lives immediately adjacent to that subdivision at 115 High Street. And the woman who lives there raised some very serious concerns about having the bicycle path in her backyard. She was eager to have the trail, but wanted to see what flexibility we might have. Due to the narrowness of the easement, we have almost no flexibility. We're trying to figure out a way to put up some screening or whatever the design might ultimately be. It would be great if we could revisit this easement with the developer, with the board, perhaps with Peter Matchak, and try to assess how we can accommodate this resident's concerns by perhaps making minor modifications to the easement. And I'm looking to the board for some guidance, like where do I go? How do I raise this issue? Certainly designing it right now online here is not the place to do it.
I would think Peter can reach out to you and give you some input, how that might be, come back to us.
Yeah, I will reach out to Attorney Winters to see what the best approach with that would be. So, thank you.
That would be great. I look forward to hearing from you.
We can't hear you, Joel.
Oh, how about now?
Yep.
Yeah, I just said thank you. I look forward to hearing from you.
Thank you. So the next person with their hand up is Tom L. Tom L., please unmute yourself and introduce yourself with your name and address.
Hi, good evening, everyone. Tom Larino. I live at 6 Burnham Circle. And my question may be better addressed in an executive session, but I want to throw it out there for the group that a few ComCon meetings ago, it was noted that the fill used on our properties was substandard. And as Michael and Tricia witnessed, and many others of you have witnessed, that our yards basically look like washed out rocky messes. So could you please let us know if this is being addressed by the town in this process, and if the goal is to have the developer fix the issue by redoing our yards?
Peter, do you know if the Exhibit A covers that? Exhibit A to the
Yeah, I'm going to ask
45.
Attorney Winters, is that question better off for executive session or? Give us a 1 minute.
Yeah, I just wanted to make sure my audio is
We
back
have,
on.
the Exhibit A is our schedule of deficiencies. Would the question of whether
Yes.
one of those includes the yard issue be something we would go into executive session for? Or is that more of an objective question of like, hey, is it in the deficiencies list or not?
I think it's more of a factual question on the deficiencies list. My recollection, and this is why I hesitated for a second because I wanted to grab the list, see if I could point to it easily. My recollection is that it is on the list. It was identified by your consultant on the bond estimate list. Lot grading, stabilization, retaining wall, loam, rake seed, established growth, shade tree ceiling, acceptance plan, detention basin, line striping, address groundwater breakout. So it's not there in one line item, but I see it captured in several line items.
Ask is that I have been coordinating all the punch lists for the neighborhood, and I was working with the Venutos directly. Since they are no longer in the process, I was communicating directly with Steve Ross, who has recently become non-responsive, and does not appear like he wants to complete any of our punch list items. So we're going to need to coordinate our efforts, and what the neighbors need to understand is what's going to be addressed by the town and what are we going to need to address.
So it sounds like there might need to be some coordination between town council and the neighborhood. Is that something, town council, that you would do separate from today?
It would be separate from today, but also this letter that we're going to author is a public document. And so we can absolutely share that actively with the residents, and they can compare it to their notes.
So, and I'm, being more of a lay person because I'm not familiar with construction the way some of our other members are on the board. I can say from a lay person's perspective, who's not a construction expert, it's not very clear to me what on the schedule of deficiencies could be yard related. So I certainly think it would be helpful to translate this list to the residents a little bit so that we have a clear communication, not just with the developer, but also with the community. And it's very clear what, if anything, is missing. On that topic, can I ask clarifying questions about the rider? Now that we are communicating with the developer, could we, as a town, in theory, get another rider for the bond to cover a greater list if there are missing items?
I assume that question was directed at me. The
Yes.
subdivision control law gives you the ability to up the security as you find necessary. So if you find that it's necessary and warranted, of course, you're going to need the evidence to back that up, and that would be your consultant's expert opinion. And you can go back to the applicant and demand that they raise the bond if it's insufficient to cover the completion of utilities and infrastructure that it's supposed to cover. So there is a statutory process for doing that. You've already done it once. And so you haven't lost that right.
I would say my position in this, because more for discussion with the board, is I would be very, I think it's very important that we use and exercise our ability to exercise the bond as a tool to communicate and get this fixed. At the same time, I would not want to pull a bond that's not sufficient to address the neighbors' concerns or the requirements of the planning board, which I think are interrelated. And so I would urge the board to make sure that we properly communicate, connect town council to the residents, figure out, essentially translate this list to the residents' needs, and make sure that any gaps are addressed either in the list with our consultant or through discussion with the developer about fixing the rider so that we can actually enforce this potentially correctly.
So if that's a possibility, how does that relate to a 45-day notice?
If that question was directed at me, I would keep those things kind of separate and apart. We're initiating here an enforcement action, and so it needs to be based on the evidence as we have it here today, and that's that letter, the punch list, etc. Whether or not you choose to, in addition to that, revisit the bond amount with a developer that may or may not be interested in cooperating with you raising the bond amount. That I would keep that as a separate and distinct item, and we can put it on your agenda and discuss it another time. I mean, suffice it to say, we don't have additional funds beyond the $350, $520 that's already bonded. So that's where we're at today. So I think we should stick with that. And if you want to discuss what might come next, we can do that in a separate session.
Just a comment. I think I understand what the attorney said. Makes sense to me, and I see the importance of making sure that the residents are given a repair that is fair. Could a point of departure be to have some communication between the punch list that the neighborhood has put together and CGC, the third party consultant that we have, so they can just provide at least an initial clarification for them to understand how the punch list includes some things maybe, but I understand how starting the process of 45 days makes sense to keep this apart, but at least provide clarity, because it may be there.
Well, I mean, the two things, to me, the two things are so interrelated. We can start the 45 days today, because today we have this list. We have an actual list of scheduled deficiencies today that we can act on to potentially start the 45 days if we so choose. At the same time, though, in that 45-day process, it sounds like a negotiation that could creates a punch list of performance that could last past the 45 days. During that time, whatever's happening in people's yards could, in theory, get worse. And other things could happen that get worse. And so the two things become interrelated, whether we like it or not. So I think it's in our interests and in the developer's interests, who presumably doesn't want us to act on any bond, to all work together to clear up that any issues that have been missed, we can address as quickly as possible so that we don't worsen the situation as is for anybody, including the developer. That would be,
and
to me, they're interrelated. I'm having a hard time separating them, other than I can see a punch list in front of me. Not the punch list, deficiencies is what we have. We have an official deficiencies list, but what I'm also hearing is that we don't know if it covers the concerns being raised by the neighbors, so we should explore that. That is directly related to today. That would be my
May I just point out,
Residents want to share the punch list they have. I'm happy to share that with GCG and go from that standpoint. But I think, Attorney Winters is pointing us to what we have in our ability in our lane right now is what is the bond amount as is.
And just for the record, just looking at the list, there is an inflation and contingency item attached to it, which would, it makes a lot of sense and would help on that regard. So I personally don't think that we should delay expediting the process that our attorneys are recommending, because I think, like we've said before, the more time passes, the worse it's going to be for the residents, and this needs to be started being addressed ASAP.
Attorney Winters, do you have anything else to add?
Just one quick comment, if I may. We're very focused on the bond because obviously that's what's, the basis of the notice of deficiency. But I didn't want it to get kind of lost in the conversation here that we issued legally enforceable subdivision approvals, and the developer is under a legal obligation to comply with them. The bonding is a funding mechanism. It's somewhat related, but it's not the end all and be all of compliance. And so the developer is still under a legal obligation to comply with the plans that we approved and the rules and regulations of this board. And so even if we didn't have this bond or any other form of security, that would still be true. So if there are things that are beyond this list, not on this list, that occurred, in the last couple of weeks, or that might occur in the next couple of weeks, those are still fair compliance issues for discussion. We have a right to insist upon full compliance of the approved subdivision plan and your rules and regulations.
So I think we have a few more public comments. We kind of, let's complete those.
Yeah, the next next person online is Sam. Sam, please unmute yourself and introduce yourself with your name and address. Yeah, you're coming in a little broken up, Sam.
I don't know what I can do to make it clear, but I hope you can all give me clear.
I can barely see him. Yeah, Sam, you're coming a little broken up. I'm going to ask you to relay any message via email to myself, the town planner, Peter Matchak at pmatchak, which is MATCHAK, at Ashland, Mass, MASS.com, and I can relay that message to the planning board.
Can you hear me better now?
No, I cannot hear you now. At this time, I would like to move public comment to the folks in the room. Sorry, Sam. So at this point, please step up to the podium, and you're gonna have to unmute yourself, which I will do, and then I will move forward.
Sure. Hi, my name is Sean Cavanaugh. I live at 32 Whittemore Drive, and I am a future member, or a member of the future HOA charged with managing the stormwater management system as set forth in the purchase and sale and operation management of leases or the mortgages that we sign. First of all, I have a procedural question. And I'm encouraged by this discussion, but in terms of requesting the list of deficiencies and the letter of demand, is that something we need to do a public records request for, or will it be posted online? It's difficult as a party of this project to follow
what we see as problems without having seen that at this meeting. So I guess that would be my first question is how do we receive these?
I'm going to email it to Vivian with your verbal request.
Thank you.
So, and I'll let Vivian distribute.
Okay. I will try to keep my comments concise on this because this development has been a very long and arduous process that began in 2014 when an individual named Paul Croft proposed a development on Whittemore Drive and a second development on Burnham Circle, which hadn't been named at that point. This development that started was originally 6 houses on Whittemore Drive that were completed, I believe, around 2016 or 2017. And there is a division within what you guys are referring to as a neighborhood between the original 6 houses and the 7 new houses on Whittemore and Burnham Circle. We as a collective have legally agreed to manage a complex stormwater system that has 6 parts, a rain garden at 34 Whittemore Drive, a catch basin at 36, a small basin behind 40 Whittemore Drive, as well as all related stormwater systems with the new catch basin in Burnham Circle. We, as a group, the original 6 houses, have been very invested in following the progress of this stormwater system and development, as well as within the neighborhood. So I just want to make it clear that there are a number of different actors in here, or parties involved. I would say that the town has a vested interest in this. The 6 or the 13 of us as a collective homeowners association charged with managing the stormwater system have a vested interest in it, as well as the 7 new households who have their own list of complex issues with respect to their houses, their yards, and everything. So I think as you're framing this in your mind, you need to be sure that we are not simply a unilateral group of individuals with the same concerns. Though I am very concerned with my new neighbors getting their yards and their houses completed as per their purchase and sales and the agreements they made with the builder. I am primarily concerned with the HOA and our responsibility to protect the wetlands. This system is larger than I think most stormwater management systems for a neighborhood of this size. Again, there's an extensive operation management list that was developed in July of 2014 when the planning board originally approved this development. And as such, we are charged with managing this system in perpetuity, which according to the O&M could cost each household up to upwards of $1,000 per year to maintain and upkeep the stormwater management system. So as a prospective HOA, we are deeply concerned with the deficiencies of the system, not only the deficiencies in the new development, the large catch basin behind Burnham Circle, but also deficiencies within the existing system, which have not been addressed satisfactorily through the development. Again, the history of this is a history that has changed, this development has changed hands a number of times. Mr. Croft was funded by Mr. Stephen Ross and Chelsea Development. And though, Mr. Ross's attorney mentioned that they recently purchased this, he has been the primary actor, the funding manager behind this project through several different developers, at least 5 or 6 over the years. Interestingly enough, Mr. Ross had a similar problem with Mr. Croft as happened with Mr. Venuto, in that the original development with PRC developers fell apart when Mr. Croft had a similar or major medical issue and he defaulted on his loan. Mr. Ross then rebought the property at an auction, which I happened to be at because I bought my house twice. The first time during the original development, but also the second time several months later when Mr. Ross hired Dixon Wood, who completed the work on the 6 houses that were originally built. Again, we as an HOA are committed to protecting this wetlands. Much of what this wetlands, or the catch basin and stormwater management system is for, is detaining silt. We don't want silt getting into the wetlands behind Burnham Circle as they are sort of the headwaters of the Indian Brook, which feeds into the Sudbury River. It's a very sensitive area with wildlife and such. The different parts of this dovetail, I think Mr. Mesky mentioned it, that the yards of the new residents of the 7 houses in Burnham Circle are very unstable. So there's a great deal of erosion feeding into this catch basin. There is a great deal of groundwater that flows from the fields behind my house on 32 Whittemore down the hill. And when it rains, it's bad, but also in the spring, there are a lot of vernal pools and vernal streams. So the catch basin is integral in protecting these wetlands. Unfortunately, on April of 2022, by happenstance, the town came across some oil leaking into the catch basin as it was being built. And fortunately, they caught the problem, but it led to several other issues that have gone on in the time since, with poor fill, poorly graded banks on this, and it's all listed in the GCG reports. And also listed in the Cornerstone reports, who is the Chelsea Development engineering firm. Getting away from my being concise. In any case, I'd just like to say that there are a number of different parties involved with different interests. The last part, I think, is the roads. The roads are, though they are not connected directly with the stormwater management system, they drain into our system. And there was some discussion from the previous developer that they were going to add elements to the O&M of the stormwater system related directly to the roads. As a prospective HOA member, I have a difficulty accepting that, as it wasn't in the operation management agreement that I signed when I bought my house. And I think that we, as a group, would really like to talk with the town council, see this list of deficiencies, and make sure that all our interests are defended in this. And again, thank you all for your time in this, but I'm just hopeful that after seeing the list of deficiencies and demand that we can find what happens. Finally, this project is massive. You know, there are massive repairs needed to do to the yards, again, which is not directly related to the stormwater management system in the sense that it's not listed in the operation management part of it, but the silt from this runoff leads directly into a basin, you know, which costs hundreds of thousands of dollars to repair, which will be on 13 individual households of lay people who are not structural engineers, who are not environmental engineers, who are not builders. And we are very concerned that that's an issue. The road as well, you know, we want to make sure that the road is constructed correctly so that it doesn't affect this catch basin and the system as well. So again, thank you for your time, and we look forward to working with you.
Just a note, everything has already been sent to Vivian. You're welcome.
We also have our email address at ashlandmass.com, Whittemore Drive.
It'll echo if we start muting. You just mute that really quick.
Okay. So when you're ready to speak, just unmute yourself.
Are we ready now?
Floor is yours.
Thank you. Hi, Vivian Williams, 34 Whittemore Drive. I'm one of the homes of the original 6, And thanks to Sean for sort of going over all that. We have been working tirelessly for years with the issues related to this. I just want to add a few points to Sean, and that will be it. I think it's really important to note that we got here because the land that we own our homes on has a really steep pitch, horrific soil, and as said by one of the Conservation Commission members, is truly undevelopable. However, back in the day, in 2014, it was decided here at Planning Board, as well as with Concom, that if they could make this stormwater system, that you guys could develop the land. The developer could develop this land. And the question at that time was, who was going to maintain this giant stormwater system? Probably bigger than what you see up on Cirrus and America's Cup. And it was decided that these homeowners, us, would maintain this. We all bought our homes without having disclosure of the O&M and knowing what we were getting into. And that's on us and that's on our lawyers. But I think it's really important to note why we're here and why we're in this state is that this land was developed and probably never should have been. The bike trail that is behind the last home on Burnham Circle is probably underwater, so that will be interesting to see how that pans out in the future. That being said, I think the other piece that I just want to mention is that through the years of time we've spent on ComCon, we have gone through the fact that Mr. Venuto and Mr. Ross have wanted to get COCs so that the homes could be purchased, they could get their money and move on. And to do that, CONCOM has done a fantastic job holding their feet to the fire to make sure that things were done properly. And as you know, they issued partials so sales could go through. One of the things that happened to make that happen was that the original HOA stated that we would not become an HOA until the last home was sold. But we said, wait a minute. The system that we're supposed to maintain is not even made. The road is not even done. How can we take care of something that's not even built? So, to get the partial COCs, we worked with Conservation and Mr. Venuto and Mr. Ross, and the HOA was revised to state that we would not become an HOA until the system was created properly. We want to do our part as citizens to maintain the system, but we cannot do that unless we have a functioning system and a functioning roadway. I'm begging your help. We want to do right by the town, by the environment, and that's the urgency here. We are filling the pond with sediment. Every single day that it rains, there is sediment and fill rolling down the hill. We cannot afford to dredge the pond to flood the roadways on Indian Brook. Please help us. I thank you for your time.
So with the help of Attorney Winters, Attorney Winters, and through the chair, I think it's appropriate to take, there's no more public comment? Okay. Is there any more questions from the board to Attorney Winters?
I do have a clarifying question for town council. I think for me, hearing the public comment, a little bit of clarity would help as far as we have this very, very narrow issue of the bond in front of us that involves this list, which we've shared with the residents. We're hearing about the residents' concerns about their obligation to maintain a specific element on their property that may or may not be related to this list in front of us. Can town council clarify a little bit what the interconnection is and what is our responsibility as the planning board versus the residents? And how does this deficiencies list relate to these concerns that we've heard about?
I will attempt to do so. our jurisdiction is limited to enforcing the approved subdivision plans and our rules and regulations, which is where this this list of deficiencies comes from. That, let's say hypothetically, everything was done exactly the way we would have wanted it done, then the entire subdivision would be turned over to the homeowners association and by extension the owners, and it would be their responsibility after that. We haven't even gotten to that stage. And so a lot of this that we're discussing here today by virtue of the notice of deficiency is to set a baseline that doesn't exist yet. And so I think a lot of our issues will be coextensive, maybe not entirely, but somewhat coextensive with the issues the homeowners and the homeowners association have. Now, that being said, the interests of the municipality, we're a regulatory agency, and that's it. And so the homeowners and the homeowners association may have completely separate and distinct rights and claims and issues under their various contracts that we don't enforce and have no standing to enforce. There may have been representations or agreements made in conjunction with their purchase and sale agreements and their closings that I would have no knowledge of. And so there may be things that are much better suited for the homeowners and the homeowners association to discuss with an attorney or attorneys of their own choosing. And so I can't really comment on any of that side of it. Subdivision control, and I know you all know this already, and the surety for it is to protect the infrastructure and the roadways and the drainage and all the things that we care about as a planning board and a municipal regulatory entity. But it has limits. It stops there. And so there are all kinds of other things outside of that our bond, our surety, and our permit doesn't cover. And so I, as town council, am not going to be able to address things that are not within the scope of the planning board's rules and regulations. To the extent we're communicating all our information to everyone, people should be mindful that there are limits to that. And I don't mean to be dismissive or insensitive, but when people buy property, that comes with certain responsibilities and obligations too. And so there may be areas where our interests, the homeowners and the homeowners association's interests diverge. I don't know, but it's a possibility to be mindful.
Thank you. And I can see that Tricia has her hand raised. Tricia, did you want to contribute to the discussion?
Yes, I do. I just have a question, and let me know if I'm not coming through clearly because.
No, we can hear you well.
Okay,
Go for it.
It's been a little strange on this end. So just to clarify, we have a bond or a surety for a certain amount, if we go to take that bond, it's kind of all or nothing, right? We have a list that was made, and this is a question, a list that was made by GCG. They put a number on it about what the completion of the road, the stormwater system, what they thought that number should be in order to complete those systems. And so by going after that bond, we would go after the whole thing, right? It's not, well, 50% of it will be given, or it's all or nothing, right? When we take that bond to complete the work that's on the list.
Unless we certify that certain items have been completed and the bond gets reduced as a result of that.
Okay. So if that doesn't happen, if the whole bond is taken, how then that money is used to complete the work, or how the work is prioritized, say if the money does not cover everything, or more things appear on the list that have to be done that were unknown before and not covered by GCG, but the town gets to decide which of these are priority. Is that right?
Yeah, I understand your question. I'm not going to be able to answer it very specifically because we're not going to know until we get there. That may be the case. It may be variations of the situation you just described. And there are also issues here that may be more appropriate for an executive session. How we're going to enforce, what we're going to enforce, who we're going to enforce against, all those things may be executive section conversations. And I'll just note that bond or no bond, the developer has a legal obligation under the permitting. And so as we go along and look at these things, if the money isn't enough, that doesn't mean the developer's off the hook. If it's still a deviation, an issue of noncompliance, a violation, if you will, we still have the right to insist upon compliance. And so we'll be examining all of those things as this progresses. And I don't want to get any more specific because we're starting to tread into areas that I think are more executive session materials.
In your viewpoint, is there any reason, is it helpful in any way to reevaluate the list of what's in the demand letter, or is it just it just doesn't have an effect, or perhaps has a negative effect given the timeline on what we're trying to achieve?
I would not suggest that now would be the time to do that, and it wouldn't also be appropriate. So let's remember the normal course of business. If let's say our security is a covenant and the developer wants to release a covenant, well, what do? They apply and they say, I've done the work necessary to have earned a release of one covenant and sell one lot. None of that's happened here. And so it wouldn't be appropriate for us to...
I think you're getting a little bit cut off. Can you just repeat the last sentence of what you said?
There's a standard process. If someone wants to certify that work has been completed and they want a release of portions of the surety, and in this case to drop the amount of the bond, that hasn't occurred here. And so there's no occasion for us to look at this and consider reducing it or second guessing any of it. As we go along, there might be an occasion to, but not as we sit here tonight. So we have our professional consultants' best opinion here of what's outstanding. And I don't see any reason to revisit that in this context.
Thank you.
So the one thing I wanted to kind of say is I was not aware as a planning board member of the rider being needed, right, in January. So that gives me some concern because if we knew about it then and we got some of these issues from the residents, maybe the estimate would have been different. So I understand right in front of us right now is a specific list of deficiencies. The residents are going to see it. The 45-day issue only relates to the deficiencies, but I think it's in everyone's interest, including the developer, to hear from the residents and make sure that we have an accurate picture so that as we start to perform or start to see the developer perform the deficiencies, those that come up because we haven't fixed this already or the developer hasn't fixed it already, we can address as they come up. I think there's an interest for everyone to connect the dots between the residents and potentially our consultant to figure out where we are all together. And I would think the developer would want that as well, so that this can be wrapped up as quickly as possible.
So that relates to a concern I have about the letter, because it says on the end of the first paragraph, specifically the subdivision is not complete for the reasons set forth on the attached schedule. And I don't think I have confidence that that is a complete list. And I'm not saying this can't be reworded, but we have this, we were told that if I got this letter, I would think that's complete.
I just lost the Zoom. Is the Zoom meeting still up?
Nope. So we're gonna.
You have it open.
What?
Okay, I'm back. Okay, I'm sorry.
Can you hear us okay, Tricia?
Yeah, yep, we're still up.
I just spun out.
Let's make sure everyone can hear us.
Yep, I'm sorry.
Is Tricia trying to talk to us?
No, I can hear you, Anna. Can you hear me?
Can you hear us?
Yeah,
They can
yeah,
hear
I
us.
can.
Okay.
I just don't have any control.
Yeah, we can't see you, but we can hear you.
Hold on, Tricia, we can't unmute you.
She's not muted though.
Oh,
Is something
Yeah, I'm
else?
the host, but I can't make.
Yeah, you can unmute directly.
I'm on Zoom and I can hear Trisha and all of you.
Okay, you know what, I'm having trouble here, so we are back up and running, I'm sorry.
So the last sentence of the first paragraph of the draft letter, specifically, the subdivision is not complete for the reasons set forth on the attached schedule. And I don't have confidence that that necessarily includes everything. And I'm not sure that if you receive this letter, you would think that might be all you have to do. And I don't want to send that message. So I think we have to talk about that.
Okay, can I ask you, what would give you confidence in terms of the due diligence? We have a third-party consultant that is telling us that satisfies the design. So if that is not, if that doesn't give you confidence, what would?
Well, that isn't recent, I don't think, right? And so there can be collateral issues. Issues not being fixed cause other issues. It's cumulative.
so what if
It
we?
may be cumulative. I do not know. I'm not an engineer.
So what if we edit that sentence to say specifically as of January, whatever the rider is, as of January 2023, the subdivision is not complete for these reasons attached, right? And that, by stating it that way, you're defining a period of time as to what was the reality on the ground at the time of the rider. We know for a fact that in January, per our consultant, these were the deficiencies. So I think we just need to amend that one sentence so that it's very clear and we're not marrying ourselves that as of June 29th, these are the deficiencies.
May I offer a
I
comment?
was under the impression the way that letter was that it was actually the inspection was prior to that, and then it was sort of updated and escalated. I may be incorrect because I never actually got the letter, or I missed it. We had a lot of emails. So, what is the date of the actual inspection?
The inspection was completed prior to the issuance of the rider.
Okay, and that was January.
January of this year.
Okay.
It was.
I think if we capture it
sorry.
by the date of the rider, that would be accurate.
I think Brian should weigh in on this. Brian?
Yeah, I'm sorry. Can I make a couple of comments, please? GCG's letter of April 7th reflects an inspection date of April 4th, 2023. A site visit was made at the request of Peter to review the current status of the work. So that's the operative date of the $350,000 figure. And second, we're tethering compliance in sort of the bigger picture with the bond amount, and those aren't the same things. This notice of deficiency is a trigger to claim the bond, and the only thing the bond covers is the $350,000 worth of items that GCG identified. It doesn't stand for the proposition that that is the only compliance issues out there. It just means those are the only ones covered by this $350,000.
So wouldn't
I
we
just wanted to
word
make
that
sure you
though and
understood.
say specifically for the bond these issues? I mean, I
Yes.
feel like that's missing in that sentence because if there are other things, this could be misconstrued later.
So you could relate it back to the letter and say, per our peer review consultant, GCG Associates, the outstanding deficiencies remain as identified in the schedule. And so you can tether it to their correspondence to this board.
Peter's taking notes. Thank you.
Did that make sense?
It does.
I wasn't very articulate there, but
was done twice. Just to clarify, I'm sorry, GCG was asked to come out, give a new estimate of deficiencies. The rider was upped. The applicant, Mr. Venuto, asked to decrease the bond amount. At that time, no work had transpired. GCG came back out and confirmed the previous number. And so that's the letter that's given in April. Then that's the number that Mr. Winters just stated in April.
Okay. So I think it's time for us to think about whether we want to make a motion to approve this letter and give the 45-day notice, not 45 minutes. That would be very efficient. 45-day notice. So what is the board's thought of that?
I'm happy to make a motion. I'm ready to make it if everybody agrees.
With the correction that
With-
Kate is, and what the
Go ahead.
council mentioned.
So I'll make a motion to approve the notice of deficiencies as with the amendment suggested during this meeting to relate to the correspondence that we received from our third-party consultant.
Is there a second?
I'll second.
Can I second, but with a question before then? Or no? Because otherwise I won't second. I do.
Okay, go. I guess we're going to hold back on the
Yeah.
motion. Go ahead.
So on the signature, like, I just want to make sure I'm not acquiring sort of any other liability by signing it as the clerk. Because it doesn't actually even say like on behalf of the board. It looks like I wrote this letter the way it's
I'll
written.
ask Attorney Winters. Excuse me, Winter. Brian, the question that was concerning the signature, the signature as it is, it's the town clerk. Is this a letter something that every planning board member should sign? Or how would you best advise?
So I wouldn't get bogged down in the weeds here. The board's gonna take a vote and potentially authorize the letter and someone to execute it. So the signature block could say duly authorized by the planning board on 6/29/23, and just keep it simple. I don't want to elevate form
Yeah,
over
I
substance.
would prefer that, obviously. So
I think
I will
let's-
second with another.
Let's get rid of Kate's name. She's everywhere. She's meeting with people. She's signing things. I think we need to make Kate much less important. So it sounds like we're going to find a way. Do we actually need to have a physical signature of someone, or it can just be a block? I will volunteer to sign if we need a signature. Like, someone has to sign this thing, or not.
You can vote for me to sign it, I'm happy to sign it.
Okay, that's a little weird, but.
I know, but I think it's only one.
But
So can we get a
think
clarification? We need to have
that's-
someone's
So I
signature?
don't mind signing it with that clarification that the attorney.
Oh,
it,
okay.
It wasn't. This literally is written like as if Catherine Jerzik is sending this, and I
Gotcha.
don't think that's
so it's
appropriate.
going to change it to Catherine on behalf of the planning?
No,
board?
he had some similar language.
Attorney Winter?
Would you like me to repeat that?
Yeah.
Sure. Duly authorized by vote of the planning board, 6/29/23.
So I will amend the motion to include that amendment to the signature.
Second.
And a roll call vote.
Deepa Venkatai.
Anna Tesmanitsky, aye.
Marcel Barjona, aye.
Catherine Jerzik, aye.
Tricia Kendall, aye.
And that's, what is that? How many of those? 5.
That's 5.
Yep. Okay. Anything else that the board wishes to discuss on this project before we move forward? It sounds like we're encouraging the residents to review the deficiencies list and communicate with Peter and town council further as necessary.
Yeah, that's all they give me, to tell you the truth. So
Okay.
But we can have Mike Carter go back outside, I can request Mike to go back out to the site and meet with the residents, and I think to get your punch list and to really, I think the biggest thing is communication. And I think this is the first step for that communication process.
And then do we need to set a date for the 45-day return of town council to give us an update, as we then need to decide if we're going to exercise the bond, right? So do we want to pick that date so it's officially on our calendar so that we know when we're coming back for a status?
Attorney Winter, do you have any clarity on that one?
Is it calendar days or business days?
It's calendar days, but I would just coordinate with your regular business meeting schedule. It doesn't require any kind of public notice, just 48 hours under the open meeting law.
Can you just repeat that? I'm sorry.
We didn't hear anything you said.
It only requires 48 hours under the open meeting law, no publication or public hearing notice. And so I'd just defer to your regular business meeting schedule. I'm guessing that you've already charted out, your meetings for the next 2 months. And we could just dovetail it with one of your existing meetings that coincides with that.
So if we send it out tomorrow.
Our first meeting in August will be right around that point.
Okay, so why don't we resolve to meet on this issue again that date? Do we need to make a motion on that, or?
I
Okay.
have no motion. The motion is to send a letter.
Okay. Great. So now we're moving to some continuances. First, we have the 16 Union.
Attorney Winter.
Oh, sorry. Thank you. Thank you, everybody.
Thank you all very much.
So then we've got two continuances. First, the 16 Union Street definitive subdivision plan continued from June 8th. The applicant has requested continuance to July 27th. Is there anything, Peter, we need to know about that continuance request?
I just have to go there. I'm sorry.
That's okay.
Actually,
Give us 1 minute, Tricia. We cannot hear you.
Sorry. Thank you.
Our volume right now is down. Give us a minute here to get organized.
This is 9 to 49 Homer, correct?
16 Union Street.
16 Union Street. So at the last meeting at 16 Union Street, they requested a continuance until July 27th. At that point, we had a continuance to act on that subdivision until July 31st. It was the motion of the board for me to go back to the applicant and get a continuance on that motion. I mean, like a continuance on our time to act. And so the applicant, with an email, I believe, under section 2 in your binders, there is a email, actually section 3, there's an email from Sean Malone, who's the engineer, and he grants us an extension on the time this planning board has to act on that subdivision until August 31st. So with that, I think it's appropriate to make the continuance into the date requested, which would be July 27th.
Do we have a motion for the
wait,
continuance?
Wait,
Can I
point of
ask a
information.
question first?
Tricia has a
Point of
question. Two
Yeah,
questions.
point of information. I thought, and I
Hold
could
on.
be wrong.
We can't hear you at all. We cannot hear anything yet. Hold on. Peter's turning you up. Okay, now you're good.
Am I good?
Yep, you're good.
I thought July 27th, and I might be wrong, was one of the dates that at least 2 members of the board could not be present. I
Yes.
can be there on the 27th, but am I wrong about that?
No, you're right.
Right.
We
So-
talked about that meeting potentially getting either canceled out or moved.
Yeah, because we would only have 3, which obviously can't, well, not for a special permit, it can't be a quorum, but I just don't feel that 3 members is great. So,
Anna, you're gone the next meeting, correct?
Sorry, you mean on August 10th? I think I'm around.
August 10th would be when we continue this matter to. You
Okay.
won't be here the first meeting in July. and then
Yes,
we'll
July
get-
13th, I'm not going to be attending. You can't do the 13th, July 13th either?
I can do the July.
Oh.
I can't do August, July 27 and August 10.
Okay. And Marcel, can you make the 10th?
August 10th.
I'm one of the ones that's out of the 27th, but the 13th,
You cannot.
I can't.
You
July
can on the
13th.
13th.
And 13th, I am available.
Okay.
And August 10th, you're available. I think I can do August 10th.
Yeah, I think I'm available.
Yeah, I can do the 10th.
Okay. So let's move this to August 10th. And I'll notify the applicant.
So someone has to make a motion.
So I had a question though of the, do we know the status of, I assume it's something with our third party and the applicant, right? That's what I recall last time, but can we get a status of that? Because,
So our third party
Yeah.
reviewed the subdivision that was
Yeah.
submitted to the applicant.
Yeah.
And the applicant has yet to respond to third party.
okay. But can we get the
I
third
can-
party
yes.
comments?
Excuse me?
Can we get the third party comments at least?
Yes.
Okay.
If I'm sorry I haven't distributed those, but yes, I will send those out immediately.
I make a motion that we continue 16 Union Street definitive subdivision plan till August 10th.
I'll second that. And a roll call vote.
Deepa Venkata.
Anna Tesmanitsky, aye.
Marcel Barjona, aye.
Catherine Jersey, aye.
Trisha Kendall, aye.
Wait, did Tricia vote?
Oh, aye.
We just can't hear her.
She said aye.
She said aye. Tricia, we
Aye.
apologize. What happens is if we don't have your volume down on Peter's computer, we get massive interference in the room. So we keep having to switch, which is why we can't hear you. We apologize.
It's a little strange from here too.
Okay.
It's the audio in the room, it's not working tonight.
We're very sorry. All
Nope,
right, next topic. 949 Homer Avenue Site Plan and Special Permit Application requesting a continuance to that same date, July 27th. I'm assuming because it's special permit, we would also attempt to move that to August 10th for the same reason? Is that accurate, Peter?
That is
Okay.
accurate. I do want to just make note, they did meet with the design review committee, and they're going back to the design review committee on July 20th. And so, I believe, and I know I distributed the design review comments to the planning board. And so that's where that project sits right now.
So the meeting is for them to respond and address the comments that the design review committee
Correct.
submitted? Okay.
Correct. They don't want to come back to the planning board until they finish with design review.
What's our shot clock on this? Because I also recall we asked for an extension on
We
the
did. And so if
site
we-
plan.
If we find this, and I think this is item number 2 in the binder, I concur, if you read my emails, I summarize in a conversation that I had with the attorney, Terrence Morris, and I outline, the conversation that we had, and he concurs that he grants us a continuance to act until August 31st.
Is there a motion to continue 9 to 49 Homer Ave?
I'll make a motion to continue 9 to 49 Homer Avenue to the
August 10th.
the August 10th meeting.
Thank you. Is there a second?
Second.
And a roll call vote.
Deepa Venkata.
Anna Tesmanitsky, aye.
Marcel Barjona, aye.
Catherine Jersey, aye.
Trisha Kendall, aye.
And we heard Tricia's vote. And that passes. Now we move on to the review.
Keep my volume down.
That's fine. We'll review draft decision and consider vote on 50 Mungunko Road. And that should be item 4, excuse me, in our binders, if you're in the room.
Just to make note, Kate Jerzik, or Catherine Jerzik, sent me some email of some corrections. They were minor, they were all accepted. And Kate, the copy of the decision that you sent to us with the edits it was all accepted and was printed and put into binders tonight.
Do we want to just take a look at it on our own, or do we need Peter to put it up on, how do you guys want to do this? Does anyone have a proposed way to go through this?
I really think the minor substance I could probably remember, and the others were typos. If people read the other one, it's very small. Which was, if you're on page 3, item D, it was about, it said this needs to be inspected, and it just, that sentence, the oil gas separator will require certification of working order per special project condition 1, which is down the bottom. And then I think the substance one. The project special conditions, if the title's on 5, it's at the top of 6. And essentially it just sort of reworded some things. It's the same intent of what was written. And I believe everything else was literally a typo. Like,
Are there any other changes we need to discuss before we take a vote? Tricia has some?
Can you hear me?
Yes.
Yes.
Peter, I had asked you a few questions about this afternoon. I apologize. I'm not seeing it in front of me. But they're pretty simple things. One was to make sure a note in there was about accessibility. It's one of the things the design review committee noted. They want to make sure the walkway from the ADA parking spots to the front door was compliant. And I think obviously they have to do that. They have to do that anyway by just to get a building permit. But and I think we have something in our conditions that makes sure that everything is ADA compliant. But like I said, I don't have it in front of me. So if that can just be looked at. The second thing was to make sure we have in there 70% native species. That was also from the design review committee list. Now that would not be part of a building permit.
And hold on just one second. So Tricia, I just want to make sure you heard. Kate said it's in there or not?
I think it is. We should find them to make
Yeah, no, we didn't.
I
did see it.
It's on sustainability page 3, item 2A. New plantings shall be those detailed on site plan. All plantings shall be native species.
Okay, that's all is bigger than 70%. So,
what was your other one? I think I saw that too, but okay.
The design review committee asked us to make sure that the walkway from the parking spaces to the front door was accessible. Now that should be a part of any building permit, but out of respect for the design review committee, I wanted to make sure we noted it.
So it's under location and use. C, it's on page 3. Location and use, I think.
Yes,
Where
two
the-
spaces shall be accessible.
Yeah.
I think it's the walkway. So I can add in I can just add in walkway.
The access to the entry, I guess.
Access to the entry shall be accessible.
And then the third thing was, and I'm not sure this is even needed in there because I think it's part of other bylaws that a permanent sign will need to go through the building commissioner. I don't know if that automatically goes through design review, but there is a process for determining if it's the right size and things, because that information wasn't provided with this set.
I can make a note of that just under special project conditions.
Okay.
But yeah, any building permit, I mean, for a permanent sign, it's a building commission, under the building sign.
And that's all I had.
Any other changes other than the ones we've discussed? Okay, anyone want to make a motion?
I'll make a motion to accept the certificate of approval site plan modification 50 Magunko Road with the edits discussed this evening.
I'll second.
And a roll call vote.
Thibault and G'day.
Anna Tesmanitsky, aye.
Marcelo Rona, aye.
Catherine Jersey, aye.
Trisha Kendall, aye.
And that passes. And now we're moving on to the MBTA memo planning, the memo on the MBTA from the planner. I don't know if that's in our packets, but we did get it online.
It is in your packet.
Okay.
Look at the tab, MBTA.
Oh.
Yeah.
Duh, okay.
Tricia, this was just probably an attachment on one of the emails, there's been no changes. But it's just an update from our last meeting, our last conversation. What Alvaro and myself did, just kind of break out the numbers and look into the conversation that we were having, especially regarding, at a minimum 20% of the land area of the entire MBTA district has to be within that quarter-mile buffer. So we took the 20% of the land area, but also 20% of the units, and then kind of broke it out. And so one of the key things to remember is that the minimum density cannot go below 15 units per acre. So we kind of took that as as a basement calculation. And so if we went at the 50 acres at the full capacity, which would be 23 units per acre, to meet our quota, that's what we could do if we were going to go for the 50 acres, which is the maximum, right? On the flip side of it, we could if we said we want to lessen the density, our buffer coverage area would have to be 75 acres. Of the 75 acres, at a minimum, excuse me, my math is jumping around now. It's all in the memo, but that's how it is distinguished between the two.
Any questions for Peter about the memo?
What are the next steps for this?
So, looking at our agenda, I have to say, just so you guys know, our agenda only says MBTA memo. We don't have a general MBTA zoning discussion on our agenda. So I don't know if we should go into that.
I think it's appropriate.
Okay.
I have no issues.
Just want to make sure.
I think the next step is to have a greater discussion with the select board, to set up a dual meeting for them to either come to one of our meetings or we go to one of their meetings and we say, hey, not hey, but we need to discuss this matter, right? And it's upcoming. It's in front of both. It's in front of the planning board for from a zoning standpoint, but from a policy standpoint, it's in front of the select board. And I think now we do know how the numbers. We have a better idea of the numbers and what we need to do. Alvaro is working on our build-out analysis, which is a new tool the state's provided the town in all 177 towns. And so we're continuing to work on it on a daily basis, and we're kind of continue to move on and on and on. But yeah, I say this summer, we should probably get in front of the select board and have this as an agenda item, because it comes down to, do we want to meet this criteria and/or legislation that the state has put on us, and how do we want to go about it, and what is the procedures?
So I know in the summer they have a very limited schedule. Have we, if we're in agreement that that's important, can we have, I guess, the chair, if Tricia can reach out to the select board and find a time that works for them?
I think.
Actually, if you can hear me, in the week before I left, I did meet with Rob Shearer, and we did discuss that about having a joint meeting, maybe us joining their meeting, or finding a common date to talk about both the MBTA situation and also anything with the housing moratorium. So he did acknowledge that they have a light July schedule. So and now we do as well, but that we would look to find a date that would maybe work, whether in July or early August. So
Sounds like a plan. Is there an agreement on that? I don't think we need to vote, but is there a general Yay? We're all,
Yeah, I just, on that memo, is that something, I mean, I know it's got a lot of details, but I do want to start getting the public kind of more information.
I'm happy to. I'm happy. I'm happy to post it online. I think number one, I'm not going to post anything that you guys don't see first. We're going to memo for this topic, so we can put it online and have it available for any public looking to read through.
the only thing I would suggest if we post it is, I don't know, I'm a very visual person, and I think it'll be helpful to have some kind of
maps.
What's it called? Yeah, like a little diagram, so like, you know, we can see a little train going through Ashland and a circle around it, or a visualization of option 2 where you have the train, but you have sections of town kind of meeting it. I think it'll be helpful for the community to see, oh, this is what it might look like, and maybe even have an actual town map so that they understand what we're talking about. You know, here's downtown, here's the train, here's these different areas that could fit into this. Like option 1 is a circle around the MBTA. Option 2 is all of these little circles all over the place, so that the public can actually visualize how this relates to a representation of our community.
We could do that. The one thing I do just take back from is if we just start putting circles on maps. You know, if we put a circle in the wrong neighborhood or the
People
wrong
will freak
area,
out.
people
So-
are gonna get. I think anytime zoning can be a lightning rod of a topic, right? So I would be very careful about where you put radiuses around. I have no problem
Understood.
putting a radius around the train station because that's in the legislation.
So maybe it's just a visual of a little train. and
100%.
Tracks.
We can do that. I think we can add. I think we should add a map.
The graphic seems like a good idea with those limitations, understanding that the legislation forces you to delineate a maximum of a half a mile, right?
Right.
Correct.
So the circle is not doing anything other than saying, this is half a mile.
Correct.
I think that circle should be publicized so that the public knows. In fact, come to think of it, I take the MBTA train from West Natick, and I just realized why there is a map. There's literally a map at the West Natick train station of the half-mile radius from the MBTA station for the public to see. And I honestly, not until this moment, I did not realize what that was. I thought that was like some kind of signal that if I run out of parking, I should park within a half-mile radius, and it's walkable. It's like motivation. So now I understand what that is, and we may want to think about that as a way to inform the public that you're standing at a train station, and here's a map, and I'll take a photo of it next time
That'd be awesome.
and show it to you.
Yeah.
But West Natick, or Natick, is clearly using that as a way to educate the public where the half-mile radius is.
Peter, don't we also have another memo that talks about like how there's a couple of zoning districts that with very minor changes? Because reading this, I think if this is all that's up there, will trigger people in the town to think we're gonna need to start from scratch.
No, 100%.
What's in this
That's
memo.
the other memo. That was another memo that was put together at the request of the planning board.
I
which
think
we
if
can
this
put
goes up,
online.
that should go up next to it, yeah.
I think that's a good thing to do.
So if we just make MBTA communities, so I know our website's not picking on the planning board, the whole town, but at least it's there. Like other communities have a lot of stuff, and we have to start getting people at least a way to learn about this, because if we do a zoning change, it involves the community. So we got to kind of get people.
So do we want to draft a little blurb about there's this thing, and we are required to do these things, and here's documents that the town is discussing?
Yeah, we can create a folder off of it. We can create a folder off of, MBTA zoning folder, and we can, we can put some hot links to the state website, state legislation,
And
the
these two
rules and
memos?
regulations, these two memos, obviously a couple, diagrams and maps that already have been created. We do have maps created around that train, so. But I think it can kind of obviously take place over the summer, and we can kind of get that process going, and as we get ready to meet with the select board.
Sounds like a plan. So it sounds like you'll look into a good date for them, late July, early August, and we'll try to get some stuff online so that we can at least share it with the public in anticipation of our joint meeting, or have a point of reference at our joint meeting. Hey, we have this website, it's up. Okay, moving on to the next
I
thing.
just want to make note,
Yeah.
we do have a public hand
Oh,
up.
sorry.
I'm sorry. Amanda, would you like to unmute yourself and
Hi guys, can you hear me?
Yes.
My name's Amanda Walsh. I live on Pine Hill Road. I'd really appreciate a section on the website for this, like what's done for the other planning board projects, just to get more info on it as a resident. Like I've heard about this at the state level, but yeah, I have no information. Like, what does this mean for an Ashland resident? What are potential options, that you guys are considering? Any information would be super helpful. In addition to that, are you guys also planning to get public input on this as far as like density goes, and if you guys plan to do a more dense approach versus a less dense approach? Is that something you guys are going to consider as well?
I think it's something that is very, personally, I think that's extremely important. And what's required to comply is a bylaw change that needs to pass by simple majority of town meeting. In order for a bylaw to be proposed, we will need input from the public as soon as possible. So I would visualize, we would meet with the select board end of July, early August. We would discuss the best way to involve the public, and we would find a mechanism to do that as quickly as possible so that we could gather public input early on in the process rather than waiting until the end of next year, which is our deadline, and then rush, right? So the sooner we get public input so that the public can feel assured and understands the process and understands what our options are, we can make better choices as early in the process as possible. That would be my preference, so that we're not waiting until the end of 2024 to meet a deadline. Does that answer your question, Amanda?
Yeah, that's exactly what I'd be looking for. Just to have some type of understanding of what's being considered, and then, taking the public's opinions into account.
Thank you. Any other public comment? Anything further from the planning board on the MBTA issue? Okay, moving on to the review of the associate planning board member position document. Trish and I worked on this draft together. Our thought was to post it on the town talent bank site, I guess, or the town has a looking for people site, and this would motivate folks to fill out a talent bank form. As we know, Kevin is stepping down from the associate position. We're very sorry about that.
Can we give her a chance to recant? No.
And we would post this, as soon as we can, as long as the draft is something that works for all. I think we drafted this with a deadline of June 30th. Obviously, we should probably change that to July 30th to give applicants a full month of July to apply, and then that would give us the month of August to review the applications and maybe even deliver some recommendations if we are having a joint meeting with the select board. Perhaps that can be addressed. Any thoughts on the draft other than changing the date of the deadline? Tricia, anything you want to add?
Just that we had, I think,
Hold on,
you and
Peter has to turn you up. Hold on.
Sorry. And I can't.
Yep.
I can't see any of you either. I can only hear you. So.
Oh, can you see us
Which
now?
is fine. No, I can't see you, but I know what everyone looks like.
Okay.
But you and I had just kind of, I think, briefly discussed where it could go out to that the town managers, newsletter that goes out. It could be posted in there. It can go out obviously on the town website. You had mentioned, or maybe Peter had mentioned, that there might be a number of great comprehensive plan people that we'd hope might see this memo out there somewhere, or maybe would want to be made aware of it, to try to get to solicit people from many different, just get the news out there that would be filling with this position to try to get some really great people. It sounds like there's a lot of great people out there. So,
Yeah. Peter, would it be appropriate for me, once it's posted on a public site, to send this to the folks who applied for steering committee? I wouldn't do it in a group email, but I could do individual reach out.
I think that's appropriate.
I'll just be consistent and not miss anyone. So I can do that. So if folks are okay with that, that way we get a wider scope of applicants. And obviously, please share it with people that you believe would be interested. So do we need to vote on this, or are we in agreement?
I don't think so, but can we get the cleaned up copy? It only has a date change, but I don't think I have it by Word, like if we're going to send it out to someone.
Oh, so that give you a Word document with the July 30th
Or
date?
the PDF with, but I don't think it's.
sent out the Word.
Oh, it's Word? Okay, then I can
Did I
change
send,
it.
was it the PDF I sent out or a Word
I don't
document?
remember.
Let me see.
I think it was a Word document.
Computer does not, what? There we go. Is Tricia trying to say something? Can you make it louder?
Yeah.
I believe it was a Word document. I have it open as a Word document.
Perfect. All right, next on our agenda is the clarification update on 1060 Main Street Select Board discussion from April 26, 2023. Peter?
These minutes are in the tab known as minutes.
Oh, yep. Minutes.
So this is a question that Kate had asked about. So Kate, do you want to clarify your question on this?
Yeah, sure. So a constituent reached out to me actually and brought up, I don't know if they watched the meeting or noticed in the minutes that the select board had we're discussing a development agreement at 10 to 60 Main Street. And I thought that was odd that a case that's in front of the planning board that we didn't know about that. So I wanted to try to see what we can find out.
Can I just get a clarification? The minutes I'm seeing are March 1st. I'm not seeing April 26 minutes in here.
Thereafter.
Oh, sorry. So it's April 27th, okay.
Yeah, I don't think those aren't the minutes we're talking about
No,
here.
so we're talking about the select board minutes. It literally was like,
Oh, it's not in here. Got it, okay.
no.
Yeah.
There was
So-
one, I believe one sentence that said to provide an update of the development agreement 10 to 60 Main in the select board agenda minutes.
Yes. So what happened? I went when Kate mentioned this agenda item. I went and looked at that those meeting minutes, and then I went back and looked at the original tape because the select board did mention discussion of a development agreement and an update, an environmental update or something like that. I don't know what the exact words. And I'm not sure if actually that was on the meeting minutes or just in the tape. No, I can't remember. I don't have it in front of me. But to clarify both, the first part, the developmental agreement, that day, if you remember, with the CPC, I was learning different, and this will relate in a minute. I was learning different things about the CPC and different types of funds that could be used. And so as the CPC reported to the planning board, their funds can be used for affordable housing. So when I found this out a few months ago, I kind of noted it to Anna that, hey, maybe this is good news for us. And then I requested a meeting with Lisa Mead for my own personal, to try to understand how these complicated things work. Like, how does that happen? I had no idea. And of course, Peter was there as well. He facilitated the meeting between me and Lisa Mead. While we were meeting, Michael poked his head in the door, and we said, hey, because I know Michael has some experience with this too, maybe you can help add to this discussion about how these things work. And it was at a very high level and trying to understand the parties involved and then what step would happen next. And my big thought was like, I'm not sure of the right timing to even to introduce this into this project when we don't even know how many units we're having at 10 to 60 Main, nor the offered affordability anymore. That has been obviously fluctuating in our last few meetings with them. So that was kind of the whole gist of the meeting, is just like how, at my request for information about how did these things happen? Like I could not get my head around it. So that's what Michael mentioned at the meeting that day, that he mentioned that meeting that happened that morning. Yeah, and so it really didn't go any further than that. Of my own understanding of this thing. And then the other thing was about, and I'm happy to answer questions on that. The other thing was about an environmental update, and I asked Peter about that. And Peter, you can explain that better than I can. But it was, I'll let you add in afterwards. But basically, what happened is in March, we met with 10 to 60 Main about environmental issues at our mid-December meeting. And after that time, the DEP, of course, was continuing to work with the applicant on the project. And so they sent an email to George Campbell, the licensed site professional, and CC'd Peter on it. And Peter then, I think, copied it to Michael. And so it wasn't really it was an email. So that Michael was kind of reporting on that email, but it kind of made it sound like there was this big update. The important information on there, which I guess we should discuss at another time, really, about 10 to 60 Main, but you can go and look at the select board meeting from April 26th. But it's really about talking about, hey, besides contamination from the plume, there are some concerns they have about contaminants from the original use of the building. So that was really what the email was about. But it came across maybe like there was a big update when really it was kind of a process email. One of the other things in that email is that DEP suggested that there's another meeting that happens with DEP and the applicant and Peter and Michael, which happened. We talked about one of those meetings at our December 15th meeting. But Peter, so far there hasn't been another meeting, isn't that right?
Yes, there's been no meeting after that. There was an email on March 1st, and it was directed to George Connors, the LSP, and it was really a environmental email, right? And they do talk about another meeting, but no meeting has been planned. And then since March, the whole entire focus of the planning board has been on the design aspect of the building. And so therefore, really the civil and the environmental have really kind of been put on the back burner. And so it wasn't until the last meeting when we talked about, okay, how do we get the civil, the environmental, and the traffic up on the front burners, and then the applicant requested a continuance until August. And so no meeting has been discussed, and it was really, in my eyes, an email between DEP and George Connors, who was the LSP. I'm happy to share the email with everybody, but that is the case.
Yes, I think that at the select board meeting, Brandy, who was still then chair, had asked Michael for any update on 10 to 60 Main, and those were the two things he talked about. So as they were summarized in the meeting minutes, I think just generated some confusion about what was going on, because obviously the meeting minutes were very succinct. So
I have a kind of related to that, though. I think if there's information about a project either coming that's people are talking about or in front of us, I would like to get the information, because I feel like it doesn't feel good to have information floating around that we don't know about. You feel like I feel like I'm not doing my best job when someone's saying, what's about this development agreement? I'm like, I have no idea. What about EPA? I have no idea. And so I think I personally anyway would want to know everything, and I feel like we have to figure that out.
Yeah, I agree. It's just in this case almost it's not really what kind of just not really, there wasn't anything there to report in a way. Like, so it's kind of like, I agree with you. I didn't like that either, because when I saw the select board meeting minutes, I'm like, what? But and then I realized that the 10 to 60, the meeting was my own meeting, and I didn't realize. I was surprised, right? So yeah, I agree with you. And we'll have to, I don't know, figure that out a bit better.
I'll take the blame for the email on March 1st. I get hundreds of emails a week, and it was an email that kind of slipped through, and we never really came back to it. There was no reason to, and there was no follow-up to it. So, if there was a follow-up, I'm sure I would have sent it out, but I took it in. Their engineer never followed up with the email, so it kind of just fell by the wayside in my eyes. But I'm happy to forward it to everybody, just so everyone's aware of it. But, all these emails get flown around. Everyone sends emails every day, So if there is an email I didn't send or didn't forward, shame on me. But
So one thing we could do to make it easier, because I was thinking we can't necessarily just call each other up randomly to update, because that would violate open meeting law, right? And we all have our individual responsibility to figure stuff out. So Tricia meets with town council, and Michael walks in, and she's learning for herself what responsibility or jurisdiction does the planning board have to negotiate I believe it's affordability restriction, right?
Mhm.
This is what it is. So she certainly has every reason to do that as chair, and at some point bring it back to us at the right time. But all kinds of stuff like that comes to me, and I'm sure it comes to all of us from time to time from the community, and there's not necessarily an easy way on our agenda to share it. Like, we have a section called reports from planning board members, but it would kind of be strange if we start using that to discuss projects, right? Because that would not really work. So one thought I had is maybe there's kind of big major projects. Like right now we've got Main Street, we've got Homer. I would say those are the two biggest ones. Maybe we should have them in our updates section, so that if there's information or material that we've learned through our individual work, research, education, we can bring it to the board and it's properly on the agenda, and there's a mechanism to share and to be reminded, oh, hey, did anyone learn anything of usefulness to share with us? Obviously, we don't have to share everything, but we at least have a public meeting agenda that allows for it. Because right now we don't really have it. I can't really tell you what I've heard about Main Street because it's not on our agenda.
Yeah, I think that'd be a good idea, because things do pop up, especially when, 10 to 60 Main Street goes on continuance for months, right? And so it's not really on our agenda, and our agenda obviously tends to fill with other things. So I think that would be a good idea.
Just to invite ourselves to be like, hey, we've got two major projects. Anyone have anything they learned that they want to share? And it'll be on the agenda, and we can have a brief discussion of updates so that we don't violate those things. So, are we good with
it's not, I think it has to be, I'm requesting a topic, I think, for next agenda, because it's related. Like that email, should that be published under the 10 to 60 Main Street stuff? And we don't have to discuss it tonight, but how those things received, when do they become public?
Gotcha.
When I receive them. And I'm happy to publish it online, and it's not a big deal. I forgot about it until it was brought up to truth,
Maybe we can add subdivisions as one of those things, because Peter deals a lot with those, that like the when we need a rider. That kind of gets done by the planning office, and it may be helpful for us to know when things are getting awry with subdivisions, and it's not a topic on our
Yeah,
agenda.
just a note. Whittemore Estates was the last subdivision approved in the town of Ashland. It was the only open subdivision, and I don't see another subdivision coming down the line, which is in the extent of Whittemore Drive. So
Maybe a non-issue.
maybe a non-issue, but just to make a point, just to give everyone a little bit of a back history of subdivisions. And subdivisions are much different from special permit site plan review. Mm-hmm.
So moving on to item 9, reports on planning topics. We've got economic impact tools, scenic roads outreach, parking memo, and update on housing moratorium. Do we want to do them all together?
Yes, I'll take them all just in one lump. Economic development tool, I do want to report that I reached out to a couple towns, neighboring towns. They do not have an economic development tool. However, they were interested in what we have, so I was able to share those. I also had a good meeting.
No good deed goes unpunished, Peter.
No, I know. And so I also want to make a note that last week we had a good meeting with Framingham State. So we reached out to Merck. Alvaro and I had a good Zoom conference meeting with 2 professors. They were interested in helping the community. They thought it was a great idea of how Merck can reach out and help different communities. They have never seen a development tool of this nature, so I sent them ours. And so they were going to take a look at ours over the summer and get back to us. And so I can report that those conversations are taking place. Those things are happening. And then the scenic road outreach, we're still working on that. However, I do want to make a note that on scenic roads, and this is outreach to everybody, is that the last 2 days, I've been working with Roy Carrera. There's been a few trees, especially on Olive Street, one big pine tree near Kevin's house, which was deemed unfit, and it was rotted and it was dead. And so Roy had to take it down, and it was deemed immediate. He is working with an arborist, and he's going to get a letter stating that, upon removal of the tree, this was confirmed to be needed to be removed. And I did receive pictures of the tree. I was on site. It was pretty bad. Kevin can attest. And I do have pictures of arms of the tree that were totally hollow up the tree. And so there was 2 other trees on Olive that were dead. I have pictures of those. And then also on Elliott Street, there was 2, right around 182 Elliott Street, there was a report of a branch that almost hit a person walking by. And so those 2 trees were removed as well. I was also on site. I inspected the trees before they were removed. I have pictures, and they were all very bad. So I just want to make note of that.
Can I just get a clarification? We removed an entire tree because of one branch?
No.
Oh, the branch was removed.
There had been branches falling for a number of months, years, I would say, and the tree was dead. It was in the public way. Yep, it was in the public way. It was along a scenic way. And we're going to work to do that, but regarding what was done under emergency order.
Where do we end up when we discuss this? I was hoping that the town will always replace at least twice the amount of trees that take.
Yes, we're working on that with the town, and I know we also talked about stump removal at the same time. But
So-
I think that's a different discussion. I think these trees were deemed health. It was unsafe. I have pictures. I'm happy to share them.
Could we get them? Could we track our trees? Or to me, when we're taking down a scenic route tree, and I very much appreciate the update, but I feel like we need to start a little tree log, because I know there's that tree from 2 years ago.
The 123 Winter Street.
I remember that tree. Now now we've got 2 more.
Yep.
But 4 more. I think. I mean, I know these are quote unquote just trees, but I think it's something that's superbly important to our community. It was deeply discussed in the Comprehensive Plan Steering Committee breakout sessions. It seems like people really love Ashland's trees. So I really would love to see us start tracking this so that we understand how many trees we are going to be replanting. And I think we need to have that discussion. And actually, Peter does. No, that's us. That's our jurisdiction.
It's jurisdiction for a scenic road.
To me, the bigger issue, which we touched upon before with Roy Carrera, is the funding mechanism.
Oh, hold on, Tricia, we got to turn you on first. There you
Okay. I was just going to say, I think the bigger issue here, which we talked about with Roy Carrera before, is the funding mechanism. Like, I think all of us would love to plant, as I think Marcelo said a long time ago, 2 trees for everyone that's come down. But Roy Carrera responded that he doesn't even have funding to take out the root, to take out the stump. So I don't know how other communities do that, or if it can just, what's the funding mechanism to fund both the trees and the stump removal?
So one of the things we could do is
DPW doesn't have it.
So we could start tracking the trees. We could start tracking the cost of replacement. We could start to kind of have an understanding of what kind of funding we might need so that we can take responsibility at the right time, whether it's through some kind of bylaw or some sort of funding mechanism. So some communities have tree bylaws that allow for funding to plant trees. We could do some of that research and see if we could use that kind of funding to take care of this.
Well, I know the Sustainability Committee has been working on such a bylaw, so, and I think it included fines, but that, I don't know. I think they're still working on it. So.
Yeah, what I'm saying is we have jurisdiction to say we must replant a tree. We have no money, understood, but we should at least track that so that we have a visual of how many trees we need to find money for. So the idea that we don't have money now doesn't erase the fact that we need to find it.
Yeah, it seems like a simple spreadsheet.
Yeah. I'm not going to let this go. Especially that one tree. I have a lot of feeling for it.
But I mean, I agree, Marcelo. Like if as a planning board, maybe saying we're now up to 5 trees removed. We adamantly support your 2 or 3. Please put this on your radar screen to this. Like if that's never communicated officially to the select board, who has access to funding.
So here's where my head kind of hurts. Like where I live right now, there's clear cutting happening on the Holliston line. There's property on the Holliston line that's being clear cut behind my house. All these trees are literally being chopped off, right? Now, when that happens in Ashland, in theory, this planning board could come up with a plan of replanting in our community so that when a developer comes in and clear cuts areas of beautiful trees and we want to replant some trees somewhere else, why aren't we having those kinds of conversations, even without a bylaw? Why aren't we saying to developers that we have relationships with that come into our communities repeatedly and build here and clear cut here? Why don't we have the relationship to say, can you give us 5 damn trees to replant somewhere else? So how can we have those discussions without tracking what we're doing? But we're never going to get there unless...
It goes into a tree budget, DPW, tree budget, how does that mechanism work? It needs more money. You gotta put, it's more money, to tell you the truth. It's money, bodies, and...
Well, if we have the accounting that Anna and Kate are advocating for, then Roy could give us an estimate and say, I need a budget of X every year, and I don't have it. And then, okay, we have that.
I agree.
And I remain hopeful. I think there are local developers who care about the Metro West area, who are good about donations, about donating efforts. There's companies that do landscaping that are very generous in our community. I think if we are thoughtful about it as a planning board, even if we don't have a bylaw, we could find 5 trees to move or plant. We could figure that out if it was important to us.
For that Alden Street project, am I on again?
Louder so we can hear Tricia. Sorry, Tricia, we have to literally make Peter turn your volume up whenever you speak.
I understand. Sorry, I'm sure it's annoying. But Peter, remember, there was an Alden Street project It was another, was it a Charlie Zamuto project? I don't remember, but it didn't go forward. But we approved it, and I think something fell through on it. But as part of that approval, we did have a certain amount of money that the applicant, the developer, was giving us to plant trees, not at that site, but in other locations. And that was part of the agreement, but the project never went through. So of course we didn't get the money for the trees or the trees. So it's possible to do.
I think if we start tracking it more actively with dates and estimates, and we're aware of it, then when the right project comes along with a generous person or the right relationship is established, we can take care of this, potentially without a bylaw. So we're up to what, 5 trees now? All right, moving on. Parking memo, update housing moratorium, nothing?
Yeah, I have no updates.
Okay.
Yep.
Reports from board members and town planner on comprehensive plan. Kate, do you want to update?
I think Peter might have the most update
Okay.
because there was a meeting, was that today that neither of us attended?
Yes, there was a meeting, and I know that the project team was, voted to move ahead and request that the town manager go and approach Golson with contracts. Contract has not been signed, so I don't want to report too much, but I know that is the avenue that that project team was moving down.
I'm sorry, which consultant?
Goldson.
Golson, correct.
Tricia, any update, or Peter, design review committee, sustainability committee?
Only for the design review committee that Kevin Mowat, who is the architect on that committee, I believe he's now vice chair of the design review committee, gave us notice that his term is up at the end of, I guess at the end of this month, and that is that right, Peter? And that he would like to continue. So that I think we are going to put that on our next meeting so that we can review his application and vote if we want to confirm to continue. I guess it would be a 3-year term, I think, at that point.
Great. Any update on sustainability committee, CPC, or other?
Nope.
Okay. Administrative matters, future joint meeting with historic commission to be determined.
It's been on there for a while. Yeah, it's a space holder. Just one other note is that the town DPW, Evan White, our engineer, has been working to update our MS4 with our stormwater committee, which is it's a stormwater policy. It was brought to my attention, and so I had a meeting with the consultant, who is Fussin O'Neill. I think from a staff level, we're gonna meet, but also I think from a planning board standpoint, we will most likely we're gonna have to set up a meeting with Fussin O'Neill to talk about stormwater. I introduced the point where maybe we should have a joint meeting with SWAC, which is our Ashland Stormwater Committee, our Conservation Commission, our planning board, obviously maybe a larger group meeting, including design review, because stormwater affects all 3 communities. Obviously, all 4 committees. We, as a planning board, or you as a planning board, have the site plan, obviously, authority. However, the Conservation Commission issues the stormwater permits, and they do all the enforcement. I do not have any enforcement regarding stormwater, and so it could be an opportunity for all a couple committees to meet and to discuss stormwater matters. And that's it.
That's it?
Mhm. We just have minutes, and I just want to obviously make a formal thank you or state a formal thank you to Kevin and Kevin's volunteer efforts with the town of Ashland to sit as the associate member of the planning board. And Kevin will be missed. However, as a young dad, I understand why you can't make these meetings.
I will say I found your perspective to be really helpful to the board, and I do wonder if you have feedback for us, maybe not today, but when the time is right, if you're comfortable. I, for one, would enjoy getting feedback from you as to things we can do better, or things that that you believe we should be thoughtful of, now that we don't have your wisdom anymore. So, great. And now we have our minutes, right? Well, the next meeting of July 13th. I know I will not be there, but that is our next meeting, July 13th.
July 13th is our next meeting, and then our second meeting in July, we are light with Deepa and Marcelo absent. So it will be Tricia, Anna, Kate. And so
Okay.
at that point, we can discuss the agenda further.
Okay.
We had
I assume.
1 minute.
Yep.
Am I on?
Yes.
I thought we had decided we are not meeting July 27th. Wasn't that the decision?
I think I think, Tricia, you said maybe it's not even a good idea, because what decisions can we really make comfortably?
I thought that's what and I'm
Yeah.
fine. I can attend July 27th.
Yeah.
But I thought when we were discussing this, we decided that we would not meet on that day because because Kevin won't even be there. A three-person
I think that
discussion.
makes a lot of sense. So if we don't have a meeting on July 27th, how many do we have in July?
2.
Um,
Oh, 1.
Do we want to or need to find a replacement? Or we want to, just like the select board, have a light July?
I think it's likely. I mean, we've already continued, and Peter will have to follow up on those continuances because it's not what they requested. But we've already continued those things out past that date, past July. And remember that I believe Rob Shearer was hoping to have some kind of joint meeting in regard to the MBTA and housing moratorium. So it's obviously not our own meeting, but we would be filling it in with another
Exactly. So like, for
important meeting.
example, I don't know when the select board meets, but we could in theory have a meeting on one of their Wednesdays in late July.
Yeah.
Possibly,
Okay.
yeah.
Sounds like a plan. All right, moving on, our minutes, and then we're done. We've got 3 sets of minutes. One is a joint executive session with the select board of March 1. Then there's a joint meeting with the select board of March 1, and our April 27th minutes. Does anyone have any changes to we'll go in order. The joint meeting with the select board that somehow I was not at, which I don't really remember, but I believe it's possible.
That was just that little thing with the Wildwood Covenant that we had to allow them to be able to construct all the units at one time.
Did I really skip that?
I'm not sure you could make it. I think there was just a few of us there, but we had already discussed it, I believe, in planning board, that we all felt the same way.
Gotcha. Okay. So this is the 7 p.m. joint meeting that I was not at. Does anyone have any changes?
I was not at that one either, so.
Okay. All right, any motion on that set?
I'll make a motion to approve the March 1st joint meeting with the select board meeting minutes.
And Deepa, I think you're the only one who can second it.
Yep, second that.
And then I think it's just Tricia, Deep, and Kevin who are voting.
Deepa Venkatai.
Kevin McLean.
Trisha Kendall, aye. Oh, okay.
Sorry.
You both did it.
Mhm.
You're good.
All right, we're good.
And then we've got the March 1, 2023, 6 p.m. joint executive session that was Tricia, Anna, Deepa, and Kevin. I had no changes.
I didn't have either.
Tricia, any changes from you?
No.
Kevin? And I'll make a motion to pass the March 1, 2023, 6 p.m. minutes as is. Is there a second?
Second.
And a roll call vote.
Venkatai.
Anna Tesmanitsky, aye. You're not on that one. So it's Kevin,
Kevin McLean, aye.
Trisha Kendall, aye.
and that passes. And then we have the April 27th, 2023 minutes, where we were all present.
I have a comment. Starting on line 60, it says, Mr. Arjona suggested that the applicant explore elevating and integrating the walkway materials into the entire width of the street open space to connect to the historic train station. That's really not exactly what I said. What I said is to elevate the entry of the driveway to connect to the patio or the plaza that they were proposing on their side, not across the street with the train station. So if we
I
could
don't think
address.
Peter has taken the notes, so you might have to repeat that.
Nope, I'm gonna listen to the tape tomorrow.
Okay,
Yep.
Yeah.
okay.
That's the only.
I know exactly what the conversation we were having, and, yep.
Sorry, I want to go back to the March one. Looks
Oh.
like 4 of us were present, and the voting is all over 300. You were present too.
For the 6th or the 7th?
The first March one,
The 6 PM?
yeah.
Oh, I didn't vote.
Yeah, so your first line here,
Oh.
300, and then there's 400, so the voting counts are different in that paper.
I'm so confused.
Sorry, I
So the 6 PM, I was there.
You were there.
So I thought I voted, I'll vote, I will, can we do that? Can we add my vote to approving the minutes, or?
So the meeting here, the
Oh.
voting here, call to order has only 300, so we should make sure that it's consistent. Yeah,
So you're saying on page 2 of
second
the
line.
6 PM minutes, it should say 4-00. Right there.
And while adjourning as well, 400. Yeah.
It seems to me that Anna needed to leave.
Is that what I did?
Doesn't it say that? Doesn't it say that in the meeting minutes that Anna needed to leave?
I must have left. So I think that explains, I must have been late and then left early. That's not unheard of. So I'm thinking we leave it as is, just to be on the safe side and not vote again. Sorry.
You can't leave it as is because it says you voted.
Oh,
So
hold on. So I must have been there and then left early.
Must have been there to open it, and then.
Got it. So we just need to amend it in that first paragraph to say 400. So with that amendment, let's take another vote. Is there a motion to pass it with that change?
Second that.
I'll make a motion, you seconded it.
All
Okay.
right.
Roll call vote.
Deepa Venkatai.
Anna Tesmanitsky, aye.
Kevin McLean, aye.
Trisha Kendall, aye.
And what about April 27th?
So I propose on line 6 to not, I don't have the quantity. I think you could just had received email correspondent, unless you feel strongly about filling in the number.
It was it wasn't on the tape, so unless you have a note.
I do, but I don't know if you want to hold up approval of minutes over that.
It just, you can
So I would say received email. I think,
Excellent.
receive the emails.
yeah,
It's not material.
no,
Just put a plural S.
yeah.
Perfect.
Any other changes? I'll make a motion to pass the April 27th, 2023 minutes with the change Marcella proposed and Kate proposed.
I second.
And a roll call vote.
Deepa Venkatai.
Anna Tesmanitsky, aye.
Marcelo Arjona, aye.
Catherine Jersey, aye.
Trisha Kendall, aye.
And that passes, and now it's adjournment. Any motion to adjourn?
I'll make a motion to adjourn.
Second, everybody aye. And we adjourn
Aye.
at 10:28 PM.
Thank you.
Thank you, Tricia.
Oh, thank you, Anna. I appreciate it.